Good morning. The hearing session is now open. It forms part of the examination of the Waverley Local Plan Part 2. My name is GJ Fort and I am the inspector appointed by the Secretary of State to conduct the examination and to report to the Council in due course. The format of the hearing is a focused and structured discussion that I shall lead. So before I go any further, could I ask the representatives of the council to introduce themselves, please?
Morning, sir. Wayne Beglan, B-E-G-L-A-N, Council on behalf of the council. And today I have with me Mr. Longley, Mr. Ellis, Miss Dove, who will be returning to the room shortly, I'm sure, and Mrs. Nash, who will be dealing with some site specifics.
And you have some colleagues joining us online, I believe, as well.
So yes, perhaps they can introduce themselves. Here we go.
Good morning. My name is Paddy McEntee. I'm with Atkins, a principal environmental scientist, and was technical lead for the SA. And I'm joined by my colleague David McLeod, who assisted as part of the wider SA team.
Good morning, it's David McLeod here. As Paddy says, assisted on the SA. Thank you.
Thank you.
And so then finally, just as we had on the first day as well, we have Dr. Riley behind us on HRA matters should they arise.
Thank you. If I could ask others in the room to introduce themselves, please, starting with Mr. Chapman.
Good morning, sir. I'm Jesse Chapman from D&M Planning.
Good morning, Andrew Munson from Reside Developments.
Good morning, Graham Ritchie from Wolf Bond on behalf of Antler Homes.
Good morning, sir. Tim House. I'm representing myself. We're a resident with an interest in one of the properties.
Good morning, sir. Matthew Good from Pegasus Group on behalf of William Lacey Group.
Morning, sir. Chris Roberts, Boyer Planning on behalf of Ashhill Land.
Good morning, sir. Estelle DeHaan, QC of Council, also on behalf of Ashhill Land.
Morning, sir. Charlie Banner, QC on behalf of Monk Hill Limited.
Good morning, sir. David Neame from Neame Sutton. I'm here today on behalf of Bewley Homes PLC, Reside Developments, Monk Hill Limited, Redwood Southwest, Crown Hall Estates and Castle Properties.
Good morning, sir. Judith Ashton on behalf of Waits Developments Limited.
Good morning, sir. Richard Moles, Council on behalf of Waits Developments Limited.
Good morning, sir. Mark Barrett from the Home Builders Federation.
Good morning, sir. Michael Wood, WSP Planning Consultants on behalf of Ptarmigan Land.
Good morning, sir. Mark Busey, DHA Planning on behalf of Bellway Homes Strategic.
Thank you. So the programme officer for the examination is Charlotte Glancy, who should be the main point of contact prior to and after the hearing sessions and should be copied into all correspondence. Now will be a good time to switch off mobile phones or turn them to silent. And if I could ask Charlotte to give us our usual housekeeping remarks, please.
Morning, everyone. This is what to do in the event of a fire. In the unlikely event of fire or other serious incident, the alarm in this building is a siren. If alarms are inoperative or inadvisable in a bomb emergency, the instructions to leave will be given by word of mouth. If the alarm sounds, leave by the nearest safe fire exit. Please note the position of fire exits from this room. Do not stop to reclaim personal effects. Do not use the lift. Proceed to the assembly point, and this is located during the daytime until 6:30 in the evening at the far end of the Berries playing field opposite the council offices, and after 6:30 in the evening at Waitrose car park. And please remain at the evacuation point until instructed that it's safe to re-enter the building. And the toilets are on this floor, out of this corridor, and then turn left. And then the toilets are on the, sorry, turn right and the toilets are on the right-hand side. Thank you.
Thank you. So the hearings are being filmed and live streamed. I presume everyone is comfortable with that. So the matters to be discussed today will be focused questions based upon and taking forward the matters, issues and questions and the associated written statements received. I am tasked with considering the soundness of the plan in accordance with the criteria of the National Planning Policy Framework and also whether it is legally compliant. The hearings are intended to assist me in that regard. In submitting the plan, the Council considers that it is a sound one and this is a starting point for the examination. So if you are challenging the soundness of the plan, then you have to explain why and what changes might be necessary to make it sound. I have read and will take into account the hearing statements that have been prepared and also the original representations that were made. So there's no need for these documents to be substantially repeated in your contributions today. So instead, the aim is that the discussion moves on from those documents and deals with specific questions that I have or areas where further clarification or explanation might be useful. At times, I may ask for a more general contribution or a summary of your position. When contributing to discussions, it would be helpful to me if contributors would stick to the matter in hand and refrain from commenting on unrelated matters. In order to test the plan for soundness and legal compliance, I will need to ask questions. You will see that I've already been doing this both in written correspondence with the Council, in the published matters, issues and questions document, and in earlier hearing sessions. And both the Council and other participants have responded to these. So the questions will continue today. However, anything that is asked should not be taken as demonstrating a particular predisposition on my part. I will normally start a particular topic by asking the Council for responses to questions I have before indicating that I wish others to comment. For those of you in the room, if you wish to comment, then please indicate this by turning your nameplate on its side. And if you are joining us via Zoom, if you can use the hands up tool. I may also invite contributions from you on specific points where I think this may assist the examination. In the course of discussion, if you wish to highlight certain parts of your statements or other documents that form part of the examination, then it will be helpful to me if you could provide the references. Those present in the room should use the microphones when speaking to me, and those joining on Zoom should make sure that they are unmuted when speaking to me, but muted at all other times. If any of those joining us on Zoom experience technical difficulties, they should make contact with the programme officer in the first instance. It is open for the Council to propose further changes to the plan, and I would ask that they keep a record of possible changes that arise during the discussions. Any changes that would constitute main modifications will be subject to future consultation. The examination remains open until my report is submitted to the Council. However, no further representations or evidence will be accepted after the hearing sessions have finished, unless I specifically request otherwise. Moreover, I am not expecting any further written submissions during the course of the hearing sessions, but I may request further material should discussions indicate that that would be useful. There will be a short session at the end of each sitting day to ensure that any suggested modifications or additional items, such as topic papers or other evidence I may request, suggested during the course of discussions have been adequately recorded. So are there any questions at this point about the procedural aspects of the hearings? Okay, in that case, if we could now move on to the substantive matters for discussion this morning, which is matter 6 of the published matters, issues and questions. So this relates to the general housing requirement and supply aspects of the Part 2 plan. So moving the discussion on from the matters, issues and questions, and in the light of contents of hearing statements received and discussions on other matters earlier in the week, I intend to start the discussions this morning with some questions following on particularly from issue 3, questions 3, 4 and 5, which relate to the scope of the plan. So starting with the question, my initial questions to the council on this. So you will have read, and no doubt we will hear more this morning about the borough's 5-year supply situation. So my opening question, Mr. Beglin, is in your view, is the LPP2's role to secure a 5-year supply on adoption?
So thank you for that as the opening question. There's a short answer and a considerably long answer to that point. The short answer is no, it isn't. And we saw from the structure of your questions that these issues were going to arise at some stage during the debate. And it's a matter for you whether you think it would be most helpful to have the long version of this answer now so that people can debate it, or if I deliver it at some stage further on in the discussion. Happy to do it either way, as it were.
The long version, please, Mr. Beglin.
All right, well, yeah, well, then, sir, if that's done at your direction, I feel no guilt about what follows. So we did ask yesterday, by way of housekeeping, if you had access to the principal judgments that are set out in your notes, and I'll be making some reference to those now. So it may be a useful time for people who want to refer to those judgments to bring them up. And so, sir, that's Wokingham and Tandridge, and including Tandridge at first instance as well.
Please proceed, Mr. Beglin.
Thank you, sir. And just by way of introduction to these points, of course, you know, in terms of the council's case and what was said on day one, that in terms of the spatial policies and the strategic policies that are set out in LPP1, we have drawn attention to policy ALH1 on page 48 of LPP1, because that deals, first of all, with the number of net additional homes to be provided, but also the locations. So those two things, we say, are clearly intertwined as a matter of strategy within LPP1, and that is how the matter was pursued from that time onwards. And then again, just to give you some references from the introductory section of LPP2, that point is taken up in paragraph 1.3 on page 5 in the introduction, where LPP2 notes that there will only be provision for housing in certain areas of the borough. And then there's further explanation on page 9, paragraphs 1.24, 1.25, making the points about which towns and parishes have chosen to allocate sites to meet the strategic requirements of the local plan part 1. Those parishes are identified in terms in 1.24, 1.25, as is further explained in the housing sites chapter of LPP2, It will not be allocating sites in these parishes listed above. And then just to complete for your note where the other introductory comments to that part of the discussion take place, they are in chapter 7, and it's 7.3 to 7.5 on page 127. And also paragraph 7.9 on page 128. And that makes the point, that last paragraph, in terms about the requirement to review local plans within 5 years of adoption. So you know what our headline points are in relation to that regulatory obligation that falls upon us and when we need to carry it out by. And so setting that as the tone, if we turn to the case of Wokingham first, Gladman Developments and Wokingham. And so what I'll do is take it at a relatively modest pace, but just give you principally the references for where we say the most important features of the case can be identified. The introduction is important, Mr. Justice Lewis, paragraphs 1 through 3. It sets out the nature of the legal challenge under section 113 and the essence of the criticism in paragraph 3. In paragraph 2, it identifies what that particular development plan document was dealing with. The MDD dealt with development management and allocations. And then we see the criticism towards the end of paragraph 3, residential development across the borough without first ensuring there had been such an objective assessment of housing need. So that was the essence of the criticism that's being made at that stage. Then the legal framework is set out in a way that is at least largely uncontroversial as between the parties before you. Reference to section 19 and what that requires in paragraph 7, having regard to national policies and advice, and having regard to any other development plan document which has been adopted by the authority. Then various other parts of the regulatory framework and indeed the MPPF are dealt with, including paragraphs 150, 158 and 159 in paragraphs 16 and 17. And then in relation to the facts, we see the discussion that relates to the core strategy, paragraph 19, adopted on the 29th of January 2010 to guide development up to 2026, describes at a high level policies to guide where development will take place within the borough. And CP17, so just there to note the point that all of the key policies that were being addressed in these cases, unsurprisingly, because it's the modern way of doing things, are the at least formulation. So you see the at least formulation there. Paragraph 20, you know our reasoning behind that is so that we don't accidentally introduce an artificial cap should we get beyond our identified level of need. That is the calculation that leads to in dwellings per year then follows through. And then paragraph 22, CP17, of the 13,000 odd, nearly 10,000 to take place on 4 identified sites referred to as strategic development locations. Then there's more detail about the MDD that was before the court. Paragraph 28, and here again I invite you to note that in this case and in the Tandridge case, where the essence of what the relevant development plan document was seeking to achieve was drawn from the text of that document itself, in much the same way that I invite you to draw from the paragraphs that I referred to when I started this morning, the scope of LPP2. So then we see what the judge referred to at paragraph 28, taking some of the introductory sections from the MDD. And then specifically the purpose of the MDD is firstly to allocate sites to meet the overall housing requirements set out in the core strategy. So they're mirroring what we are seeking to achieve by LPP2 and the way that we've chosen to do it. Further allocation to do with other uses of land and detailed policies and setting boundaries. So some similarities between that exercise and ours. And then paragraph 30, recording the claimant's submissions to the inspector. Line 3, claimant consistently submitted not be possible for the inspector to determine if the MDD was sound unless he first ensured that it had been an objective assessment of need for housing as envisaged by paragraph 47, carried out in accordance with the process contemplated by para 159. It contended, and so the argument continues, and then in parenthesis, and so the amount of land to be allocated. So that was bound up in the submissions that the claimant was making to the inspector and in due course pursued before the High Court. At paragraph 32, we can see some of the inspector's reasoning, and I simply draw attention that these are perhaps matters of fact difference rather than principle, but I draw attention to the absence in that case of any commitment to review the course strategy. Here there will be a review next year, and then further on down there's a passage that starts in the indented text. It appears to me such a review may also be necessary for Wokinham's core strategy, specifically if the strategic development locations are seen to be failing to deliver the levels of development necessary to fulfill the core strategy's spatial vision. And so if you, as it were, transplant that to our case in terms of what you're likely to hear today, then the difference is between the 4 strategic allocations that were proposed there and Dunsfold Aerodrome here, and perhaps the golf course, which is another one of our strategic allocations. And then we can see as we move through the inspector's report, and then paragraph 37, the inspector identifies 4 main issues. First of those is housing requirement. Paragraph 13, councillors use the housing numbers in the core strategy for the purposes of calculating the requirement. This is appropriate. And then in paragraph 38, the second issue identified is the supply, housing land supply. And then so as you read through that, you'll see the references to 5-year supply there, and the fact that 5-year supply was going to be met. So to that extent, it wasn't an issue in that case on the facts. But in terms of the way that the inspector concluded that paragraph, we can see, or that section, we can see paragraph 19. 4 lines into paragraph 19, it's also clear the council's strategy of concentrating in a limited number of strategic development locations carries with it the risk of under-delivery in the short term. On the other hand, the allocation of more sites outside the SDLs risks undermining the overall strategy, potentially leading to further shortfalls in delivery from those bigger sites over time. And then the issues are identified at the foot of the following page of the report, just before paragraph 43. Issue 4, did the inspector fail to determine whether or not there was a 5-year supply of housing land available, or if he did determine that issue, did he give adequate reasons for his conclusion? First issue, the inspector's approach. We see, again, paragraph 44, the reference to the at least. There was no determination about objectively assessed need, and it appears to be virtually common ground around this room that there's no obligation on you to look at objectively assessed need again. It's what follows from that that is more controversial. And so if you follow that discussion through, what you'll see in paragraph 50 on the conclusion on that issue, clear from the inspector's report, not intending to endorse figures of the core strategy as figures that would reflect an up-to-date, as it were, objective assessment, but whether the MDD was sound in its allocation policies for the figure of at least 13,230 dwellings, bearing in mind that might be an underestimate of the housing needs for the borough. So that's the basis upon which things proceeded there, and the basis upon which things will proceed here. Then we get to the second and third issues, the assessment of soundness, and we can move straight to the discussion, which starts at paragraph 58. In my judgment, the starting part of an analysis is the scope of this particular DPD. The at least is mentioned over 20 years, as the inspector recognised might well prove to be an underestimate of the amount of housing that will be required. 60, in my judgment, an inspector assessing the soundness development plan document dealing with an allocation of sites for the quantity of housing which is needed is not required to consider whether objective assessment of housing need would disclose a need for additional housing. I reached that conclusion for the following reasons. And then a series of reasons are given so that you will know have been endorsed by the Court of Appeal in later cases. So they are there to be seen, and I don't read them out now. But paragraph 65 is important. Properly read, the framework does not require a development plan document which is dealing with the allocation of sites, as we are, for an amount of housing provision agreed to be necessary to address also the question of whether further housing provision will need to be made. So that is not a question that our document needs to address. Entirely clear. And that paragraph from the judge at first instance is expressly endorsed by Lord Justice Lindblom in paragraph 32 of the Oxted residential and Tandridge case. Just to note a trite point as we're going through the authority, but worth bearing in mind, paragraph 70, even if some of the arguments that were put in support of the inspector were wrong, it was accepted, as it must be, that the framework is guidance only, and it was open to the inspector there, as it is open to you, sir, to depart from any particular element of it, if you consider there is good reason for doing so. And so, for example, even if you were to conclude that for one reason or another, we ought to be looking for a 5-year housing land supply, would be open to you to weigh other factors in the balance in relation to soundness, such as the benefits of having a plan swiftly adopted that will undoubtedly make a significant contribution to meeting housing need. No, but plenty of other factors you could put in that basket as well. And then fourth issue, housing land supply, just the last reference here. Paragraph 74, conclusion of that section, the MDD allocated the right amount of land in the most appropriate sites for the provision with which it was dealing. The question's always being tied back to the scope of the development plan document under consideration. So those are the key passages that we seek to rely on from Gladman, and I'll move on and go through Tandridge. So Tandridge was slightly different in the sense that in Tandridge, the development plan document wasn't making allocations, it was only dealing with development management. Points arose about whether or not that was a distinguishing feature in the circumstance, and the short point is that the court held that it wasn't. But so do you have access to the P&CR version of the first instance decision, or are you looking at a straight transcript?
I'm looking at the straight transcript.
So then I think we might invite you to look at in due course the P&CR report for a reason I'll briefly mention now, but I won't dwell on, and then I'll go to what is effectively the transcript of the judgment. The reason is, in the holding of the report, which distills what the case was dealing with, in paragraphs H6 and H7, these points are made. In H6, it was the claimant's submission in that case, amongst other things, that the core strategy was out of date in respect of its housing requirement and measured against a properly assessed, objectively assessed need. The council did not enjoy an adequate 5-year supply of housing. So that point was squarely put in as part of the claimant's criticism in that case. And then in the holding itself, it's paragraph H8. Applying section 19.2 that we looked at, the inspector was not required to embark upon an inquiry as to what the OAM might be, point 1, where we all agree, point 2, where we don't agree, or whether or not the council had a 5-year supply of housing. So that second question is identified expressly and a judgment is made about it. And consequentially, whether the policies which were being examined were relevant to the supply of housing. Now, turning then to the transcript, judgment of Mr. Justice Dove. And so because we're going over matters that are close to what was being decided in the Gladman case. I'll try and take it a little more swiftly. Paragraph 7 sets out what is this document, the Tandridge Local Plan Part 2. And again, I just make the point that the court took from the document itself what its scope was. Of course, that's a document that is consulted upon as part of the exercise. And those paragraphs 1.4 and 1.5 are expressly referred to again in paragraph 55 of this judgment. It then moves on to discuss the examination that took place in that case. Paragraph 37, there's mention of Gladman, and the principles that were set out there then follow. There's a clear consistency of approach here. The submissions and conclusions in that case start at paragraph 45 under a separate subheading. And so at paragraph 46, a few lines in, you will see the claimant submits as an overarching point. Inspector erred in failing to inquire into what was the defendant's OAN. Had he done so, he would have concluded it was out of date. Measured against a proper OAN, the defendant did not enjoy an adequate 5-year supply of housing. Once it was realised the defendant did not have 5-year supply of housing, then certain consequences were said to follow, and that was the essence of the argument. 51, defendant's response to those submissions, reliance on Gladman to contend that the issues related to OAN, so not just OAN, but issues that are related to that, and any associated questions of the 5-year housing land supply, including whether or not policies were policies for the supply of housing, were simply not engaged. Paragraph 53, after recording the respective submissions, the judge begins his conclusions. I start my conclusions reliance on what Mr. Justice Lewis had earlier said. Para 55, in my view, the scope of TLP2 is clear from paras 1.4, 1.5, so that's where the scope's found. Did not include an examination of the OAN. Inspector, not in my view, required to embark upon an inquiry as to what the OAN might be, or whether or not the defendant had a 5-year supply of housing, and consequentially, so that's where that part of the holding comes from within the judgment itself, whether the policies which were being examined were relevant to the supply of housing. The establishment of a new housing requirement for the defendant's administrative area was not a task which TLP2 had set itself. That logic applies exactly to this situation. 56, claimants attempts to distinguish Gladman there because Gladman did have an element of allocation to it, in my view, entirely unconvincing. Question which has to be considered always is what is the scope or purpose of the DPD being examined, whether or not it's permissive of certain development or not. And we set out in LPP2 itself very clearly its scope. Paragraph 57, setting of an OAN did not arise, and therefore, nor were questions of 5-year housing land supply, whether para 49 of the framework fell to be applied. Not the role, paragraph 58, not the role of TLP2 to consider housing need, 4 lines in. And so that's the basis upon which the judge at first instance dealt with it. And then finally, we have the appeal decision, the substantive judgment given by Lord Justice Lindblom. And it sets out the statutory provisions, again, reference to section 19, sets out key parts of the MPPF and the policies that were being debated. And then in terms of the submissions, they're recorded 24 and 25. And it's Mr. Clay's submission at paragraph 25 and the attempt again to distinguish other cases, including Grand Union investments. That argument rejected, as we see from paragraph 26, essentially for reasons that were articulated by counsel for the local planning authority and the reasons previously given by Mr. Justice Lewis, which are summarised in paragraphs 30 and following. And paragraph 32, perhaps towards the foot of the page if you're looking at the transcript, last few lines. However, as Mr. Justice Lewis aptly put it, properly read, MPPF does not require a development plan document which is dealing with allocation of sites for an amount of housing provision agreed to be necessary to address. Also the question of whether further housing provision will need to be made. So that's the express endorsement by the Court of Appeal of what was said below in that case. 33 is worth bearing in mind for the reference to timely preparation of adoption and adoption of local plans. Here we say our plan makes allocations. It will provide a development management update so that we're consistent with the MPPF, which is clearly important. And of course, we have our review in the relatively near future. That's something that's referred to in paragraph 34. 35, last sentence here, the inspector was examining a plan which proposed site allocations for housing, which as a minimum, so that approach again, would contribute towards the agreed housing need for the area. Exactly what we say we do. 37, the basis for distinction between the two kinds of situations that have been described was rejected there. And 38, I agree with Mr. Justice Dove. He concentrated rightly, in my view, on scope or purpose. Halfway down, an inspector conducting an examination must establish true scope of the development plan document and what it is setting out to do. Only then will he be able to properly judge whether or not that scope and within what it has set out to do is sound. And then reference back to section 19.2, having regard to other development plan documents, which we have plainly done. And then the express, as it were, approval of paragraph 55 of what Mr. Justice Dove had said. And that's where the issue in relation to OAN and the 5-year supply of housing is linked, and the consequential issues as well. So again, specifically endorsed as the correct approach by the Court of Appeal. 39, as the judge recognised scope of LPP2, plain from its text, from the text in the introduction, and from the policies it contains. So you can look at all of those things when you're trying to reach a proper view about scope. It supports the core strategy, does not substitute for the policies of the core strategy an amended or new strategy. So we say that's critical here, because we're not seeking to revise or review in any way the strategic approach that's set out in LPP1. And there we can see towards the end of that paragraph, authority not obliged in this particular plan making process to use its evidence base to ensure its local plans meet full OAN. And so it continues. Suggestion such an exercise was called for in this process and misconceived. And so I think the last passage that I draw your attention specifically to is paragraph 45, where again the submissions on behalf of the local authority are recorded. And again, there's express approval of a statement of Mr. Justice Dove, this time taken from paragraph 57. Since the question of setting an OAN did not arise, nor were questions of 5-year land supply, whether paragraph 49 of the framework is in point, follows. You don't need to reach decisions on those issues. So again, another specific endorsement. So, sir, it's for those reasons that we say that it's clear when you look at LPP2, its text as well as the LDS, what the scope of that document was. It wasn't seeking to readdress these needs. It was seeking to make specific provision in relation to specific areas entirely consistently with policy ALH1. And the issue of 5-year housing land supply is not something that you need to determine. It is something we will have to return to during the course of the review. And so that was an extremely long answer, and I do apologise, but hopefully I won't have to say any of that again.
Thank you. I think we'll get on in more detail to the strategic sites in LPP1 during the course of the discussion, but in terms of neighbourhood plans, and we've heard already, and we will hear again about the slower progress than anticipated on the adoption of some of those documents. So is it within the scope of LPP2 to set out a kind of remedial approach where things aren't, in terms of neighbourhood plans, aren't coming forward as quickly as anticipated?
So no, because that would be reviewing, as it were, and revising the approach to the neighbourhood plans in the same way that taking, as it were, you might be invited to take stock of what's happened at Dunsfold Aerodrome and say, well, because of what has happened there hasn't followed the trajectory that was envisaged at the time of LPP1, therefore remedial action, to use that phrase, is probably a useful handle for today's purposes, it is required to be taken. That's simply another way of the parties to this examination inviting you to calculate the 5-year housing land supply as it now is, and to invite you to take remedial action in that regard, bearing in mind the scope of LPP2, which specifically hived off those neighbourhood plan areas. So this is not a matter that was left, as it were, untouched by LPP2. It's hopefully clear from the paragraphs that I referred you back to precisely what the approach was and what was envisaged when this plan was consulted upon and when it was submitted. And so in those circumstances, what one can't do now is seek by another means to mount a case that suggests, well, now, just because of the way that circumstances have transpired, in fact, we do need more allocations. That's not this process. This process is to test the allocations that have been made for their soundness.
Thank you. Mr. Banner.
Good morning again, sir. It seems to me that there's two aspects to the answer of your question, which was, should this plan secure a 5-year supply, which is the legal aspect, I must it as a matter of law do so. And then even if it doesn't have to, should it as a matter of policy do so? And Mr. Begnan allied those two questions, but they are different. He focuses principally on the must. And the context for considering all of this, which is fundamental, is to understand what it is that those who are asking for more allocations, what it is we're asking you to do and why. And Mr. Beglan, on behalf of the council, as he did 2 days ago, fundamentally mischaracterizes. We are not asking you to revisit the OAN. We are not asking you to unpick the judgments made in LPP1 as the amount of housing that needs to be delivered over that planned period. We're relying upon that OAN and those judgments. We want you to give effect to them, which this council hasn't and refuses to do. It's absolutely fundamental to appreciate that. The reason why various people, such as Mr. Neame, Mr. Burden, myself and others, are saying the allocations need to go up, the reason why is twofold. Without that remedial action, for want of a better term, without that slack being picked up, as Mr. Moores described the other day, two things will happen. Firstly, the 11,000 odd, 11,210, I think it is, the figure in the LPP1 won't be achieved. And secondly, the at least, the boosting beyond that won't be achieved. It's two separate elements. We won't even achieve the minimum, but it is a minimum prefaced by the words at least. And that is fundamental to understanding then whether the cases, the two cases that Mr. Beglan just took you through at length, actually assist him or assist us. So I then turn to those cases under the heading of must, this is the legal element side, and then come to the policy aspect of the answer to the question later. And I'll start with the Gladman or Woking case. That was fundamentally, as one sees at paragraph 3 of the judgment, a case about whether at the daughter document stage, and at that stage it was an allocations document, it was incumbent upon the local authority to revisit OAN, or whether the purpose and scope of the daughter document was to give effect to the judgment in the parent document. And it was the judge rejected the proposition that it was necessary, legally incumbent to revisit the OAN. Well, as I've said already, that's not what we see. We are actually doing the opposite of that. We're doing what the judge said, which is to give effect to the parent document. Housing land supply, which is a specific point you raised, was considered. See paragraph 73 and 74 of the judge. Not a question of the court saying in the context of an allocations daughter document that one doesn't need to consider whether the allocations generate a 5-year supply. That the allegation by Mr. Tucker was that the inspector hadn't grappled with 5-year supply. The finding of fact was, as a matter of fact, he had done. So this judgment provides absolutely no authority for the proposition that in the context of an allocations document, it's unnecessary to consider whether the allocations provide a 5-year supply. All that judgment does is to say you don't revisit OAN in an allocations document. And as I said, we're not doing that. We're seeking to give effect to the LPP1 figure. So much for the Gladman and Wokingham case. Then we get to Oxted. And again, the principal thrust of that judgment was about unpicking OAN. But in terms of the aspect of the judgment where Mr. Beglan relied upon, where the Court of Appeal said it wasn't legally necessary for that inspector to look at 5-year supply. The context of that is set out at paragraph 40 of the judgment. Can I invite you, if you've got on your screen, sir, to go to paragraph 40, which quotes, excuse me, it quotes the inspector and draw attention in particular to paragraph 12. LP2 in that instance was a development management tool, not an allocations document. Mr. Beglan skipped over that. That's fundamental. The LP2 in that case was not about delivering housing. It was about development management, material, the usual kinds of things that those kinds of plans have. And that is absolutely fundamental to understanding paragraph 39, which is really the crux of that judgment, where the Court of Appeal endorsed what Mr. Justice Dove had held at first instance. And the judge held, and the Court of Appeal endorsed, that fundamental, it was 38 and 39 actually, but fundamental was the scope or purpose of the local plan part 2. And in particular, I see at 39, it's the third sentence, the explicit purpose is detailed planning provided locally in the assessment and determination of planning applications. You know, what the doors and windows should look like, materials, nothing to do with delivery of housing. And as that was it was in that context, and that context alone, why it was considered that it wasn't necessary for that document to generate a 5-year supply. And that's fairly unsurprising. And one has to read also the considerations set out at paragraphs 31 and 32, which is really building upon the judgment in the Gladman case, another Gladman case. And 31 and 32 make the point that development plans can be multi-layered, have different elements. And 32 builds on that, the multi-layered point, by saying the relevant policies in the framework, properly understood, don't require every DPD within the local plan, every layer to fulfill all the requirements described in paragraph 47. So in other words, it's not for every single layer of the local plan to do everything that the MPPF required. The point is that collectively, the overall package of DPDs must do what the framework does. The problem for this council, sir, problem with that is that in Waverley, none of the elements of the development plan, if this is adopted, will do what the framework does. We know LPP1 never generated a 5-year supply. I'll come on later to the 16 decisions on 5-year supply since this whole process started, every one of which, apart from one, Waverley overstated their 5-year supply. Every one apart from 2, they said they had one when they were found not to. Complete denial. But the point is that we know under LPP1 there isn't a 5-year supply, and we've just heard, I'm going to come to in a moment, we've just heard that the very intention of this council in preparing LPP2 is not to have a 5-year supply. This is not designed to generate a 5-year supply. Well, I'll come on to submit that through that submission, Waverley have just blown a hole in LPP2 and its Soundness, blown a gaping hole, because they've just admitted the true purpose of this plan, which is not to generate a 5-year supply. So you go back to test the paragraph 32 against the present context, and whilst it's true that not every layer of the local plan needs to discharge the requirements that the framework places on the development plan as a whole, if you stand back and ask, well, when you piece together the different pieces of the jigsaw, does the development plan in Waverley collectively discharge the requirements of the framework? The answer is absolutely not. I turn then, sir, to the policy aspect. Should it? Well, even if Mr. Beglin is right that it doesn't have to create a 5-year supply, should it as a matter of discretion? Because the highest these judgments do is say that in the discretion of the relevant decision makers in those cases, it was within their reasonable discretion to make the decisions they did, which doesn't actually really help you in deciding what you think should be the case, a matter of policy in this, exercising your discretion. And the first point is, of course, the obvious, which is that if this document doesn't, upon adoption, demonstrate a 5-year housing land supply, then as the framework is currently drawn, it would be out of date on day one. Not very sensible planning. It would mean that on the very first day of this plan coming into force, it wouldn't result in a plan-led approach to delivery of housing. It would result in planning by appeal under paragraph 11D of the framework, which is how things have operated since LPP1. So that's the first point. The second point is there's obviously been a history of delay. Obviously, there's various people such as Mr. Neame to my right again to deal with that under your later question. There's been a history of considerable delay, both in the preparation of this plan and in terms of the delivery of the LPP objectives and sites, etc. In the context of the need under the framework, paragraph 60, to boost significantly the supply of housing. That also tells in favour of LPP2 making further allocations as it is able to in order to deal with the situation. And the suggestion that it shouldn't, because it should await a review of LPP1, would be to sanction chronic failure in housing supply in this district. Again, not the opposite of positive planning. It's anyone's guess when LPP1 review will happen. I was in this room in December 2018 with my client, Mr. Neame, on a planning inquiry in relation to Longdean, doing closing submissions and on that planning appeal. And it was, I think, that week that LPP2 went before committee members and was thrown out in its current form. And here we are 3.5 years later, and it's not yet even been adopted. And it may still be some way off. Doesn't give you a great amount of confidence that the review of LPP1 is going to be quick. And during that time, real people in real need of housing in this district, people who might have to commute out to less expensive places where there's more homes, their needs are going unmet. It's not good enough. And then we could say, come back to the point I made at the beginning, that what Mr. Beglin has just told you is that in calibrating this plan, the local authority proceeded on the basis it didn't have to secure a 5-year supply. And that was the fundamental approach this local authority took. And it proceeded on the basis that not that it shouldn't, but that it couldn't look at more allocations in terms of numbers than those proposed. Well, that shows that fundamentally the local authority preparing this plan has A, not planned positively, but done the opposite, and B, completely misdirected itself about the remit of the plan. That sounds in terms of SA, because it shows it is failed to have regard to reasonable alternatives, because it's discounted higher allocations, higher numbers on the basis that it couldn't provide for them, when in fact that's wrong. And it fundamentally shows this isn't a sound plan as drafted. And you asked us at the beginning to say, well, if we're criticising, what's the solution? And the solution, as far as we are concerned, is at paragraph 5.3 of our regulation 19. There needs to be we invite you to make interim findings, as is not uncommon in this sort of situation, to the effect that I've just set out and that will be elaborated by us during the course of today, and invite the local authority to provide for more, the higher number of allocations, and to consult upon what those should be. Otherwise, there's absolutely no chance that real needs are going to be addressed, and the plan-led system simply won't happen in this borough, because the development plan will be out of date on day one. That's all I wish to say, so thank you.
Thank you, Mr. Bennett. I just want to ask the question about, so we've got the modular approach to the planning system here, and taken together that as to meet those relevant aspects of the framework. So what's your view on the neighbourhood plans aspect of the development plan in this district?
They don't provide an answer, because firstly, the existing neighbourhood plans that are in place haven't generated a 5-year supply, and ultimately that's the relevant aspect of the MPPF, and we know that because we know the current state of play in 5-year supply. And secondly, more than one of the neighbourhoods, Hazelmere and Milford, don't make allocations, so they aren't doing what was expected of them. So they don't provide an answer in this context.
Mr. Neame.
Thank you, sir. I just want to make a couple of small supplementary points, if I may, to the very good points that Mr. Banner has just made, but just to set the context for the facts here in terms of the scope, going back to your question about the scope that we discussed earlier in the week. We have to remind ourselves of the position reached at the local plan part 1 examination, sir, and you'll recall that I and others took you to various paragraphs of your colleague's report. So that's CD 226, just for your ease of reference. And the local plan part 1 examination considered, amongst other things, that the detail of the OAN resulting in an increase to the housing requirement from that originally proposed by the council at the start of the examination. The consequence of that increase was that the scope for the local plan part 2 was modified. And it was modified in part to address the housing need, or the uplift in housing need, as a result of the discussions on OAN and the eventual housing requirement figure arrived at during that examination. And we see that expressly referred to, sir, in paragraph 48 of your colleague's report, where he starts by saying that part 2 of the plan is therefore an essential element of the council's housing delivery strategy. However, if it were only to allocate smaller sites, referring to the original scope, as described by the submitted plan, it would be too inflexible to enable the housing requirement to be met, and there would be a significant impediment to delivery. He then goes on to talk about modifications and confirms that they are necessary in order to clarify the role of the Part 2 plan and to assist with the delivery of the increased housing requirement established by the main modification reference he cites. It's crystal clear that the scope for the local plan Part 2 was critical in terms of meeting that minimum housing requirement. And you'll recall, sir, you were also taken to paragraph 57 of the same report, which identifies the risks to supply, for example, in terms of variations to start dates and delivery rates at Dunsfold Aerodrome and unforeseen impediments in bringing other sites forward. So we'll come on to the detail that relates to that particular paragraph later. But again, a direct connection between the two parts of the plan, that this local plan part 2 is intended to meet the housing need. And so again, apologies for taking you back to it, but you'll recall that we looked at the LDS, and the LDS, which is the council's position, sets out the scope for this document, and it clearly says that it is there to meet housing and other land use needs. So it's crystal clear, sir, that the scope of this plan by the council's own making is to meet that housing need. And there is direct cross referral to the supply issue as a result of the paragraphs I've taken you to. So it is clearly the case that as a matter of policy, that a 5-year supply needs to be established. That is the purpose of this document. You've already heard, sir, that there is currently no 5-year housing land supply. That's effectively a matter of common ground, because the council are at least referring to their lack of 5-year supply in the development management process currently. And I will take you to detail in answer to questions later on, sir, but you will have seen from the trajectory evidence that we've submitted that at no point will the council be able to demonstrate a 5-year supply if this plan is adopted in its present form. It will fail, and it will continue to fail. You also heard reference to the fact that there will be a review of the local plan part 1. Well, sir, unless I can be directed to it, I can't see where the timetable for that review has been published, accepted by members and laid out. It's certainly not in the local development scheme. So there is considerable uncertainty over the route that Mr. Beglin suggests is the right route. I think those are the points I just wanted to make as supplementary points now, sir. I will, of course, come back to the detail on supply matters in response to later questions.
Thank you, Mr. Mools.
Thank you, sir. You were given a very long answer relying on Oxted and Gladman. The short answer to what those cases decide can be found in Appendix 4 to our Matter 6 representations, which is the report on the Woking site allocations DPD. It's page 13, paragraph 38, last sentence. Moreover, the established legal position, and the footnote references Oxted and Gladman, is that a site allocation plan, such as the one subject to this examination, does not need to reconsider the housing requirements on which it is based. That is an accurate statement of the ratio of those two cases, no more, no less. Mr. Beglin invites you to read those cases as establishing a different proposition, that questions of whether on adoption the plan would, the allocations in the plan would deliver a 5-year housing land supply are beyond the scope of the examination of that daughter document. I entirely adopt what Mr. Banner said in relation to that. It's absolutely clear that Gladman establishes the opposite. If you look at paragraph 43 of Gladman, where the issues are defined, subparagraph 4, the issue was, did the inspector fail to determine whether or not there was a 5-year supply of housing land available? If it was off limits, there would be no question of whether he failed to do it. He simply had no business determining it. The answer given by Mr. Justice Dove at 73 and 74, you see it very clearly in 74, is he did resolve that issue. And the relevant paragraphs in which he did resolve it are quoted at paragraph 38 of the judgment. So far from establishing that questions of 5-year supply are off limits, Gladman demonstrates that they're firmly within the scope of an inspector's power. What's more, the inspector lawfully needed to demonstrate that he had grappled with the issue. And so we've made points in relation to the Mid-Sussex site allocations DPD, which in my submission shows how all this should actually play out with an analogous parent plan, daughter plan, and LDS. I'm sort of in your hands as to when you want to hear those points, whether you want to go through them now or come back to them.
It'd be useful to hear them now, please, Mr. Null.
Thank you, sir. So the first, I'm going to take you to 5 documents very briefly, just to give you the framework in Mid-Sussex. The first is the parent plan, and these are added to the inquiry documents on the council's website. The first is the parent plan itself, page 30 of the internal numbering. That's 39 on the PDF version. And what we've got here is the preamble to policy DP4 housing. We can see the second paragraph on that page sets the minimum requirement, and the penultimate paragraph describes the role of the DPD and the fact that there's going to be a review of the district plan. So exactly the same situation here. You've got the policy itself over the page on page 31. Notably, policy DP4 actually commits to a review with a specific start date in that case. That's the last paragraph of DP4. Council's committing to preparing its site allocation DPD in 2017, to adopt it in 2020, and it's going to review its district plan starting in 2021, submission to the Secretary of State in 2023. Over the page on 32, you've got a table setting out the minimum requirement, but also the state spatial distribution. So again, on all fours with what Mr. Beglin was saying is a special feature of LPP1 here. Yeah, so you've got the spatial distribution of the housing requirement according to the various settlements. Then page 34, DP6 and the settlement hierarchy. And then at 36, you see the neighbourhood plan strategy. And it's part of the strategy of Mid-Sussex to deliver allocations through a number of neighbourhood plans. So again, that's the same modular approach. Next document then is Inspector Bohr's examination report on that parent plan. And if you go please to page 9, starting at paragraph 32, at the foot of the page, the settlement hierarchy. You can see that he requested a main modification, adding that table showing the spatial distribution of the housing requirement and the minimum requirement for the settlements. Then at page 10, paragraph 35 onwards, he deals with 5-year housing land supply. And at 37, he talks about the role of the DPD and the need for speed in words that clearly echo what he said when examining the Part 1 plan in this case. So picking up 37, second sentence, however, the calculation of supply in a strategic plan in which some of the allocations will be made in a subsequent plan or in neighbourhood plans is not an exact science, and there are inevitable uncertainties about start dates, delivery rates, and the developability of sites in the 5-year supply schedule. Should the supply fall below 5 years at any time, the council would be less able to direct development through the plan-led system. It's therefore very important that the plan has resilience should, for example, one of the sites take longer to start or is slower to deliver. And to this end, this plan and the forthcoming site allocation DPD need to ensure not only that a 5-year supply of housing exists at present, but that a rolling 5 years housing supply can be maintained in the future. So seeing it very much as the role not only of the parent plan, but also the daughter plan to provide the 5-year supply. Then at 38, talks about his interim conclusions and various alternative suggestions, which the council rejected. He says, given, this is midway through the paragraph, given that sufficient strategic allocations have now been made and the site allocation DPD is intended to follow soon after this plan, this is a sound position to take. So again, exactly the same position, finding the parent plan sound, partly on the basis of a swift adoption of a site allocation DPD. That echoes what he says in paragraph 57 of the local plan part 1 report, which we've already seen. Then third document is the DPD itself, just to show you what that actually provided for. Page 4 is the executive summary. And this sets out the aims of the site allocation DPD. Note in particular Roman 1, the aim of the DPD, the daughter plan, is to allocate sufficient housing sites to address the residual necessary to meet the identified housing requirement. So it sees very firmly the role of the daughter plan as meeting the residue necessary to hit the minimum requirement in the parent plan. Page 7, what is the site allocations DPD? Again, in the second bullet of paragraph 1.1, exactly that same role explained. The site allocation DPD allocates additional development sites to meet the residual necessary to meet the agreed housing requirement. So the overall goal of this is to meet the minimum requirement in the parent plan. And then at page 33, under the heading Strategy for Delivery of District Plan Housing Requirement, we can see at paragraph 2.23, part of the strategy is in the penultimate bullet, allocating within neighbourhood plans. And then fourth document is Inspector Fox's report on that daughter plan. This is really the key document in my submission that shows how it all is meant to work. Paragraph 21 on foot of page 10. So here he's dealing with the sustainability appraisal, and he says it's important, midway through the paragraph, important to recognise that the plan is in effect the daughter document of the district plan, meaning that its scope is necessarily limited by the strategic parameters of the district plan. It would therefore be inappropriate if the SA for this plan were to provide input into strategic options, which will no doubt be assessed at the review stage of the district plan. So first point, he's got very firmly in mind the limitations of what the daughter document is meant to do. We'll go on and see what those limitations actually mean in practice. Paragraph 35 on page 13, he deals then with the quantum of housing provision. Sets out in 35 the minimum requirement. 36 notes that the strategy relies on 4 big strategic sites, including in Roman 2, the Northern Arc at Burgess Hill. Then 38 identifies the residual requirement to be addressed in this DPD. 39 says the DPD provided, when submitted, provided for an oversupply of 2.95%. He then recalculates that in paragraph 40 to show a 5.5% oversupply, and says that that's appropriate having regard to paragraph 74 of the framework. Then crucially at 41, he says, I assess below whether I consider the delivery rates of the proposed housing provision, including the strategic sites and the allocations in this plan, are realistic. And he sort of makes the point in the last sentence that the basic maths that the council has come up with is accurate, but one needs to look actually under the bonnet and see whether the delivery rates of the strategic sites are borne out in reality. 42, he makes the important point that it's necessary to have a trajectory and proposes a main modification that goes to one of your questions you've asked later on. 43, he then goes to look at the delivery rates on first bullet point, the 4 strategic sites. He addresses in 44 whether that's something that it's appropriate to do. He says it's reasonable. The second sentence, reliance on strategic sites is set in the district plan, found to be sound. However, given the length of time that's elapsed since the adoption of the district plan, that was March 2018, I consider the question to be a reasonable one to ask. So there we had adoption of the parent plan in March 18, examination in May 22. Here we've got adoption of the parent plan in February 18, examination in July 22. So there it was 3 years, here we're slightly over 4 years. So even more reasonable to look under the bonnet and look at those strategic sites. He then goes on to do that in turn with each of the sites, including at 46, the Northern Arc. And crucially, at the bottom of 46, he says that exercise is critical to the soundness of this plan, which in turn impacts on whether the residual housing requirement in this plan is sufficient for soundness. And then at 58, he reaches his overall conclusion that he's satisfied actually, even with the reduced totals, there's a realistic chance of delivering sufficient homes. And then at 85 to 86, he reaches his conclusion on the 5-year housing land supply, factoring in those revised delivery rates for the strategic sites. Then the final document is the LDS, just so you can see what Mid-Sussex's LDS provided for. You've got page 4, page 5 in the PDF, paragraph 4.1. The Mid-Sussex district plan was adopted in 2018, complemented by the DPD, which will allocate sites for residential or other uses to meet the housing and employment needs identified in the district plan. And then you've got the table over the page. The role and subject of the DPD is to allocate non-strategic and strategic sites of any size over 5 dwellings to meet the residual housing requirement over the rest of the plan period, to meet the full plan requirement and to maintain a 5-year land supply, etc. So again, in my submission, the LDS is comparable to this case. The reference to allocating sites of any size to meet the residual housing requirement clearly echoes the comments of Inspector Bohr and the reference that the council indeed relies on to allowing allocations of more than 100 units in the Part 2 plan. So what we've got is a similar parent plan with a minimum requirement and spatial distribution, similar comments from Inspector Bohr about adopting the daughter document quickly and the risk of delivery on strategic sites. You've got a similar local development scheme. You've got a similar problem in that delivery of strategic sites is behind what was anticipated. As a matter of principle, you've got Inspector Fox saying, I'm entitled to look at that, because it goes to the very question of whether the daughter document is doing what its purpose is, i.e. delivering the minimum requirement in the parent plan. And I can certainly go back and look at delivery of strategic sites given the 3 or 4 years that have passed. What the only difference is the response of the local planning authority. Mid-Sussex allocates sufficient sites that there's a buffer. Waverley treats the minimum as a cap for certain named settlements, ignores the delivery on strategic sites, and apparently its stated purpose of this plan is not to provide it with a 5-year housing land supply on adoption. So in our submission, that encapsulates the proper scope of an examination in a site allocation DPD, where the parent plan is analogous to that which is before you, sir.
Thank you. Mr. Bruce, is this further on the scope of the plan?
It is, with regards to the neighbourhood plans, if I may. Yeah, I just really want to stress the concern with the reliance on some of the neighbourhood plans. I'm not going to repeat my written submissions or anything else that's already been made today, other than to say, in response to the council's hearing statement, I do consider it wrong to wait for a review of local plan part 1 to pick up any slack through the delivery of neighbourhood plans or otherwise. Just to highlight the case of Cranley, where my clients have an interest which is outside the scope of local plan part 2, as we all know, and this is one of the 4 main settlements in Waverley. The neighbourhood plan has been in preparation now for some 9 years. Back in April 2020, the examiner first identified some fatal flaws, including raising doubt as to whether the neighbourhood plan should even include a housing strategy at all. In the 2 years that have passed then, we've had a further Regulation 14 consultation, which the parish council themselves have identified some flaws within. They have paused and have committed to undertake a further Regulation 14 consultation on a revised version of the plan. Again, not to repeat my written submissions, but Waverley clearly can have no confidence in the neighbourhood plans, and in particular Cranley delivering their critical part of the local plan part 1 requirements. This is an issue for the current development plan, not a review of the plan. This is an issue for the current plan period. Within my representations, I have therefore suggested that some flexibility must be applied to local plan part 2 to ensure that the neighbourhood plan settlements, in particular Cranley, do deliver the housing requirement set out through neighbourhood plan, local plan part 1. Thank you.
Thank you, Mr. Busey. So you suggested a policy change.
I have set out a policy which is in my written submission. I won't repeat it unless you want me to, but it is essentially to cover an eventuality that neighbourhood plans don't come forward, that the presumption in favour of sustainable development should be applied to consider planning applications to meet local plan part 1's requirement in essentially what is a policy vacuum for a settlement such as Cranley.
Thank you, Mr. Busey. Mr. Wood, is this another scope? Comment on the scope of the plan?
Yeah, it's really just, I suppose, a word of caution, building on the points that have already been raised and the scope of LPP2, in the context of the LPP1 review that's imminent. Our concern is that what adding a raft of housing sites in LPP2, as others may be putting forward here, will do is ultimately slow this plan down. I mean, we've seen it elsewhere on several occasions in similar boroughs to Waverley, where this approach has caused examinations to stall significantly or ultimately fail. And now we're in no way endorsing the approach that those local authorities have taken with regards to their approach to housing delivery in the plan making process. But I think it is a very real risk here that doing that may cause significant delays, further delays to the adoption of LPP2, meaning that the housing proposed within this plan may not be able to come forward. So actually, if for you to consider, but it is pertinent that the LPP1 review is so imminent. We've heard the council commit that it will be doing its review early next year. I think it's really important that they are, held accountable to that commitment. But would it not be better to secure the allocations within this plan? And this goes back to that point of what the plan should be doing, I suppose, rather than what it must be doing, to secure the allocations proposed within this plan, rather than risking the plan to fall entirely because the council's politicians may not be able to stomach the additional housing proposed here. Thank you.
Mr. Good.
Thank you, sir. One of the problems with going towards the end of the discussion is that most of the points you were going to make have already been made. So I won't unduly take up your time, sir. It's just basically to simply reiterate that we, like many of the others, thought it is within the scope of this document to look wider than the settlements of which it's looked at. And that's evident within the inspector's report to local plan part 1, where the inspector clearly was seeking to ensure that LPP2 and LPP1 together met the minimum housing requirement, which, as you've seen through our evidence and the evidence of others, sir, that is not considered to be the case. We also note, as is noted by Mr. Neem, that the LDS doesn't actually stop them looking wider than the settlements that they looked at and providing other allocations in different settlements, and neither does the requirements within LPP1 in terms of they are not caps, they're minimum requirements. And then finally, sir, it's just that issue with LPP1. We noticed the LDS was published late last year. That doesn't provide any certainty about when LPP1 will be reviewed, which I think is a significant concern, sir. And whilst it's not a matter for this examination to consider, it is worth bearing in mind within the early part of next year, this plan LPP1 will be over 5 years old. And without that review mechanism in place, they will find themselves in a much more difficult situation in terms of housing need.
Mr. Chapman.
Thank you, sir. I'd just like to elaborate a little bit further on the matter of the reliance on neighbourhood plans coming forward. I haven't got anything in front of me to corroborate what I'm going to say, but it is a fact that the neighbourhood plans, when they come forward, in nearly all of them, that the draft documents that I've seen, the neighbourhoods, the parishes are citing the number of houses that have been that have been allocated in local plan part 1 as being, this is what we have to supply. And through the planning applications that have come forward since the local plan has been adopted, we are, where we have met that allocation, we're not seeking to provide any additional sites coming forward. Again, Cranley's been cited as being in the process for 9 years. I believe Ewhurst Parish Council, the same sort of time frame, although I think that they're very close now to adoption. But yeah, I think it is a danger to look to rely on the parishes in, for want of a better phrase, pulling their weight in helping to meet the allocations within the borough. Thank you.
Thank you, Mr. Banner.
Thank you, sir. I just want to come back briefly on Mr. Wood's point about the potential delays to the adoption of this plan, if you accept what I and Mr. Moores and Mr. Neem have said. Firstly, if we're right that this plan ought to secure a 5-year supply and doesn't, then the fact that it may take time to remedy that is a relevant consideration. It has to do what it has to do. And the delay is inevitable, regrettable from inevitable consequence of this plan having been prepared negatively. Secondly, even if that's not right, the delay that would be involved, the adoption of this plan, is plainly going to be less than the delay that would otherwise be involved between now and an LPP1 review. And it's not entirely clear that an LPP1 review would actually deal with the issue anyway, because it may just go back to the parent-daughter and we go round and round in circles with an LPP2 review following that. I mean, the track record of this council does not give you and cannot give you any confidence that the LPP1 review will A, happen quickly, and B, happen in a way that actually deals with identified housing needs. Everything that's happened in the last few years suggests the opposite. So actually the lesser evil is to sort the position out now. And thirdly, which rather relates to the second point, the politics. I mean, if the point's being made, well, were you to suggest that more allocations should be made and were the process to go through on that basis, then when it came to adoption, they might decide not to vote in the plan at all and just kick the whole thing out. Ultimately, that you shouldn't be influenced by the spectre of that, because you're not a politician. They're the politicians. You need to do what's objectively right in planning and let the politicians be accountable for their decisions later. But if that is a real prospect, then it's just as much a prospect in relation to LPP1 review. Because either way, the homes have to be provided for. So it's a point that doesn't actually tell in favour of waiting LPP1 review anyway. But the fundamental point is actually, if we're right, then this plan has to show 5-year supply, and the delay is not a material consideration in considering whether to go down that route.
Mr. Mills.
Thank you. Just to add to that, in response to Mr. Wood's need for speed point, and to remind you, you'll have a note of it, sir, that what Ms. Cook said on behalf of his client on Tuesday, that there's already a suite, as she put it, suite of asterisk sites that have been assessed, identified on map 5 in the Reg 18 version of the plan, and they've already been assessed in the SA.
Morning, sir. Couple of brief points from me. I don't want to repeat some of the comments I made yesterday, but just briefly, as Mr. Neal quite rightly says, there is no timescale or mention of when an LPP1 review will happen. The LDS is completely silent. I think that's a really important point in terms of grappling with the situation this council's in. So it is inherent on this plan to deliver the housing requirement in LPP1, and it needs to get it right. And as Mr. Banner has correctly said, there are a number of sites that have been assessed. The council have simply, as I highlighted on Tuesday, chosen to ignore them. I think it's also worth noting as well, so one of the challenges that Waverley have, and as we've discussed, is the various landscape designations and the greenbelt designations, which cover most of the borough. So actually that makes it quite difficult for sites to come forward through an appeal scenario because of the protection that's given in the framework, and particularly those higher order settlements. So the recourse quite often in these situations would be an appeal, but in some of these sites, it's simply not going to be possible. And that's going to further suppress the housing delivery in this borough. So LPP2 has to do what LPP1 expects of it. And hearing Mr. Beglin's long speech at the beginning of today, I was quite surprised at the comments we keep hearing about representatives trying to change the OAN. As Mr. Banner quite correctly said, I don't think anybody has actually made that point through this plan. We quite often do. I've done that myself, I have to say, in other EIPs, but for Part 2 plan, that's not the purpose. It's very, very clear what is required of this plan. You've obviously had parts of the Woking Part 2 plan quoted at you, which I know you're very familiar with, sir. But there's many other examples across the country: Mendip, Bracknell, Winchester. All of those over the last few years have Part 2 plans that have been adopted and have had to find additional sites to actually meet the full housing requirement. So this is nothing particularly special. It's something that's very capable of being dealt with. Also, just wanted to highlight again, sir, and I said it yesterday, LPP1, of course, only dealt with strategic sites over 100 units. So nothing below 100 units has been looked at by the council through the development plan process to date. Again, this plan should have dealt with that. I also submitted the other day, sir, the High Court challenge that the council made to my client's appeal decision, and hopefully other people have seen it. But just wanted to touch on that briefly because it does get to the nub of why we're hearing what we're hearing today in terms of the council's approach. And I think there's various paragraphs. If I can draw your attention, sir, to the council's grounds, it was paragraphs 22 to 24. Effectively try and argue that in the case of the Allfold appeal, the inspector misinterpreted policies SP2 and ALH1 in terms of what the spatial, what the settlement hierarchy and what the spatial strategy of Waverley actually says. And you'll see a very compelling response from the judge. And I'm not sure I've seen many decisions that use the word unarguable that many times over a page and a half. But it's quite clear the judge did not agree with the council's proposition on that point. Similarly, in the grounds of appeal, the council sought to rewrite national policy and indeed its own sustainability policy in terms of the requirements for sustainability and accessibility services, etc. We all know what paragraph 105 of the NPPF and the relating paragraphs say. And again, the council sought to argue that and lost. And this, unfortunately, is what we're hearing again through this EIP in terms of how the council is interpreting its own policies incorrectly. So I'd invite you, as we've said in our representations, we need to grapple with the housing shortfall. Neighbourhood plans, as you've heard, will not deal with them. Planning applications quite possibly won't deal with them and certainly won't deal with them alone. So this plan really does need to introduce other allocations as has occurred in other site allocations, DPD documents. Thank you.
Thank you. So it's now 11:05. I suggest we adjourn now until 20 past, and then we'll come back and I'll ask for your responses to those points, Mr. Begum.
Thank you, sir.
Okay, if we resume now, please. So, Mr. Beglan, your reflections on what we heard before the break.
So thank you. I'll go first and then we'll see if the other members of the team want to build on any of the matters that I say by way of reply. But first of all, in response to Mr. Banner's points to you, that the most important feature to bear in mind of this examination, we would suggest, is that it is the scope that dictates the application of the soundness principles and not the other way round. It is not for the soundness principles to be applied in some broad way for there then to be a decision as to whether or not the scope of LPP2 should be expanded. And so for that, without repeating them, if you go back to paragraphs 38 and 45 of the judgment of Lord Justice Lindblom in the Tandridge cases, and then to note on top of that as it were, when we're dealing with the cellular approach to development plan documents, it is of course for the local planning authority to make decisions as to what the scope of those documents is to be, and for the reasons that are articulated in the introduction and the various paragraphs of LPP2 that I referred to. Here, decisions have been made based on what has happened since the adoption of LPP1 in relation to neighbourhood plans and provision that has already taken place elsewhere, for example in Farnham, identified by Inspector Bohr as being the most sustainable settlement within Waverley. So all of those features have fed into the approach that was ultimately taken by LPP2 in deliberately deciding to make proposed allocations in certain areas of the authority, and that is the scope of that document. In relation to that issue about scope, where there are references by the parties to the LDS, three things about that, sir. Firstly, the statutory requirement in relation to the LDS we looked at a couple of days ago is a very broadly stated requirement in section 19. This LDS, we say, complies, but the requirements of an LDS are not particularly prescriptive in that regard, and it is unsurprising that the text of LPP2 itself provides more detail in that respect, and doubtless that's why the judges in each of the cases that we looked at actually used the text of the development plan itself to ascertain precisely what the scope of that document was. Further to that, of course, if you're trying to make sense of all of these documents and reading them together, you will bear in mind the obvious chronological point that the Regulation 19 version of LPP2 was generated in 2020. The latest revision of the LDS was generated about a year later in late 2021. So it couldn't sensibly be said, I don't think it has been said, that any generalized text in the LDS is intended to supersede the very specific sentiments that are set out in the paragraphs of LPP2 that I referred to. So that's the first point. The second point goes back to the cases, and again, without rehearsing the detail, in both of those cases, but most clearly in both the first instance judgment and the Court of Appeal in the Tandridge case, the link between considering issues of OAN, of the 5-year housing land supply, and the consequential issues that arise is plainly set out by the judge in Tandridge and expressly approved as an important part of the approach by the judges in the Court of Appeal and the lead judgment. So we noted earlier that where there were attempts made to distinguish the factual situations that were arising in Tandridge as against Wokingham, again, the judges were unimpressed with those approaches, and you've got those paragraphs. And so what we're dealing with here are statements about general principle and how tied up those three potential issues that all go to housing land supply are. And in this case, as in Tandridge, they are not engaged. In some submissions, there was a mischaracterization of the local authority's approach to LPP2, but Sarah, I'll leave you to go back to your notes on what I said on that. I don't need to rehearse those issues. But if we look then and proceed on the basis that there is no legal obligation for you to address these issues in your plan, the other point that's raised is the point in relation to policy, which should you, even if you don't have to. And the answer to that is primarily dictated by the scope of the documents, because that's how you test soundness. And we say on a proper understanding of the scope, those issues are simply not before you and couldn't be addressed in an appropriate way that would lead to the relatively swift adoption of an otherwise sound, subject to any modifications that are made, LPP2. And there are a number of reasons for that beyond the scope. There's the evidence base in support of LPP2, which was deliberately drawn and refined based on the scope. There are the consultative steps that LPP2 has been through, again based on its scope. The contribution, the significant contribution to housing that this plan will make once adopted, and that, as you've heard from others, it will do so in an area that does have very real policy constraints. And so the ability to have plan-led development is of particular importance in an area like Waverley. Also militating towards early adoption of this plan is the idea of reducing any further delay in moving forward with those allocations and the provision of housing more generally. So next, just to note as we turn on to the cases of Woking and Mid-Sussex. So you have a very specific and peculiar advantage in relation to Woking. But in relation to Mid-Sussex, of course, one doesn't know precisely the arguments that were addressed to the inspector, what happened. We can't, as it were, fully reinvestigate that case. And so we need to apply caution in how we deal with the issues that arose there. But bearing that overall approach in mind, first to think about is perhaps that the idea of 5 years housing land supply don't appear to have been particularly controversial in either of those examples. So in Woking, so you will know the facts and figures, little over 5 years left to run on the plan at that stage in Woking, and supply figures that appear to have been about a third over what Woking actually were required to provide. Mid-Sussex, the situation, if I go to the inspector's report, and so rather than to necessarily read passages, if I just give you some references now that we're dealing with things by way of reply. If you look at page 10 of the report, paragraph 21, you'll see there's a comment made on the scope of that plan, albeit that it's a comment made in the context of considering the sustainability appraisal, but it does deal with the strategic parameters of that plan. Here, the strategic parameters for us are those that are set out in LALH1, as I indicated earlier, the level of need and the particular spatial distribution that level of need will be met by. If we look at 1124, there is a linkage there between the nature of the objections that are made to the plan we see here, and in one respect it's just a function of the process, but the individuals around the table are those pressing forward for objection sites, both in the areas where we have looked for sites and indeed in other areas. If we look at page 13, paragraph 35, and the Crawley buffer that was being applied, that was in the order of 9%, 9.14%. I just make some of these points as more general observations. The uplift that we were tasked with addressing arising from Woking was significantly higher, and that feeds into the task, the overall task that was given to Waverley to do. Page 14, paragraph 36, the 4 strategic sites in Mid-Sussex amounted to approximately 31% of the need overall, and one of those sites was by far the largest. That was the Northern Ark at about 3,500. The reason I draw attention to that now is because there is a parallel in that respect for questions that we'll deal with later today relating to Dunsfold. And then the residual requirement that was before the inspector at that stage, you'll see at page 14, paragraph 38, a relatively modest 1,280 of the overall picture of 16,390. And that's clearly relevant as to whether anything that the inspector had in mind there was going to risk significant departure from the distribution that was required by the parent document. And indeed, that's a feature that the inspector dealt with within his report. But can I draw attention in particular to one of the main modifications that Mr. Moores drew attention to? Page 19, paragraph 60 of the report is the discussion of policy DP6. And what that led to was the introduction, and I'm not sure you've got the appendix to the report for Mid-Sussex, Jonathan Ball's report. So it may be useful just to add that to the library so you can see what happened. But by main modification 6, it was Mr. Ball who caused the large amount of text that Mr. Moore identified to be added as a necessary main modification by definition. And that main modification included the insertion of the section dealing with the strategy for neighbourhood plans, including this particular passage. So I'll leave you to go back and read over that section because it does contain an important parallel with the approach that we've taken and provides perhaps another example of where that approach has been accepted. But if I just read for a moment from part of that, it was said some settlements, and then a number of settlements were identified, have already identified sufficient commitments stroke completions to meet their minimum housing requirements for the full plan period and will not be expected to identify further sites within their neighbourhood plans. Pausing there, one can see perhaps the mirror between that and LPP2. But in that case, the authority have made a slightly different decision, so the text that had been inserted carries on. However, this does not preclude town and parish councils from identifying further sites within their neighbourhood plans, should they wish to do so, as a matter of promoting localism in planning. Those are my words. The plan text continues, in order to boost supply. So a further choice was left with those responsible for neighbourhood plans. And then that part of the section continues. Similarly, further sites may be allocated in the future to ensure that the minimum residual for each settlement category set out in policy DP4, which was referred to, is met based on monitoring. Now, when you compare and contrast the policies in that plan compared to ALH1, what you will not find is a direct comparator for DP4. We have DP6, we have a comparator for that, and that is ALH1, where there are specific identifications for the minimum to be provided for each of the settlements that are concerned with. In Mid-Sussex, they did it two ways. They did it firstly by settlement, that's DP6, and then in DP4, there was a broader categorisation as well by tier of settlement. Now, Waverley did not choose in its planning process to allocate numbers in that way. And so that last part of Inspectable's main modification 6 doesn't have an analogue to us. But we are simply dealing with DP6. And so when that is understood, in fact, the approach in Mid-Sussex to neighbourhood plans is clearly supportive of the approach that this authority has taken, or at least consistent with it. Page 20, paragraph 68 of the report, last sentence in that paragraph, clearly significant departures from the strategic settlement distribution in terms of either numbers of dwellings, first of all, or principles of environmental sustainability would amount to a soundness concern. So the inspector there was comfortable that the changes that were required to be made by way of main modifications could be accommodated without those risks arising. Now, I invite you again to bear that feature in mind when we turn on to discussion later and we look at Dunsfolds, and you will be reminded, I'm sure, by various parties about the virtues in environmental respects that Dunsfold was considered to have by Inspector Bohr, and they're set out loud and clear in a separate section of his report. And so one needs to consider if the challenge that's really being made when you strip it down to its bare essentials is, well, in relation to one, perhaps two of the strategic sites that were identified in LPP1, they haven't performed as Inspector Bohr considered they would have done, then what are the sustainability implications of moving away from two sites that were both specifically identified as being very well chosen sites? And to put that in context, if you look at the effect of the changes in Mid-Sussex, you can pick that up from page 22, paragraphs 74 and 75 of the report. In relation to the villages, the extent of the change was 3.1% for the larger villages and 6% for the medium-sized villages. Now, I'm not sure if we've got that comparable calculation at our fingertips, but even on my barrister's arithmetic, I can tell you that the changes that would occur here would be multiples of that. And so when we think about all of those things together, what we can see is that there is support in general terms in Mid-Sussex for the approach that's been taken here, but that the scope of Mid-Sussex was not as identified as it has been in LPP2. And the sustainability, the broader sustainability implications are clearly capable of being viewed differently. And I say that as well on top of the point that I've made, that it doesn't appear that the issue of 5-year housing land supply was put into the debate in quite the same way as it is being done before you. And so we don't know the extent of the challenge there. Moving on to some shorter points. One of the things that was said against the council's position is, well, if you look at the Gladman's case, there's also a reasons challenge there. So that means that what the court was necessarily accepting was that it was but both permissible and indeed right for the inspector to look at those issues. That doesn't follow at all. All that means is that a reasons challenge was being made. The court considered that on its own merits, dismissed it on its own merits, and at its absolute logical height, all that can demonstrate is that the court considered that that was one reasonable approach that could have been taken in those different circumstances. The issue about delay that I've already mentioned does come into perhaps starker focus when you hear around the table today representatives who have sites in Cranley, representatives who have land interests in Newhurst, and the suggestion, presumably implicitly, is that this examination ought to be considering those settlements. And then, of course, the logical question arises, well, why stop there? In terms of the relative sustainability of settlements, we know that those two are not identified as being the most sustainable settlements. And so that simply indicates the kind of delay and difficulty that is likely to be foreshadowed by the road that you're being invited to adopt by a number of participants around this table. It will, we suggest, if taken, and there's no need to take it, it's not required in law, it's not required in policy, it will lead to unfortunate delay in a constrained authority. And it's the opposite of the approach that we commend to you. So can I just check if anyone else wants to deal with some matters of detail?
So I've just got a couple of comments, so if I may, and I'll limit my comments to the scope because clearly we've got additional responses to add later on. As Mr. Beglin has said, in our view, LPP2 does the job that it was set in relation to allocating housing sites in Hazelmere and Whitley. This is based on robust evidence, which we will clearly discuss later. And it's important that these allocations are brought forward as soon as possible to contribute to housing supply. And for the reasons that you've heard, to do otherwise in relation to bringing this plan forward to adoption is likely to result in further delays. Wider strategic matters involving revisiting the scale and distribution of housing across the borough should, in our view, be properly assessed through an update of LPP1, and we can no doubt talk further about that. In this respect, it's worth noting that Dunsfold Park and the strategic sites in LPP1 are an intrinsic part of the spatial strategy that allows Waverley Borough Council to accommodate high levels of growth. And I draw your attention to the comments from the LPP1 inspector, where he's very clear that accommodating significant growth at Dunsfold on a brownfield site outside of the green belt with limited impacts on nature conservation and landscape values was by far a preferable strategy to an alternative dispersed strategy of smaller site releases in the green belt and elsewhere. And that's I think is where some of the representations are taking you towards, and that is an alternative spatial strategy to the one set out in LPP1. And I finish there just by repeating the point. We think that alternative strategy, if it is necessary to deal with the under delivery in the early years at Dunsfold Park, that is really a strategic issue that ought to be dealt with through the strategic plan.
Thank you. I mean, there are a couple of follow-up points really to that. So in terms of Mr. Banner's point on the 5-year supply and the tilted balance being engaged, you know, almost on adoption of the plan if it went forward as is. So would that result in a genuinely plan-led approach, which paragraph 15 of the framework advocates? And what would that do to the existing spatial strategy?
Well, sir, it would. What it results in is an imperfection. One of the reasons that I drew your attention earlier to the trite observation, but one worth bearing in mind, that it's open to you to depart from elements of national policy. So even if you were against us and you thought that the 5-year housing land supply was one, something lawfully that ought to be done, and two, as a matter of policy, you should do it, other things being equal, you then go on to consider, well, are those other things equal? There will be from time to time, it's a necessary corollary of the fact that there may be daughter documents where 5-year housing land supply is not considered, where objectively assessed need may have moved on, that there may be examples where plans are adopted, where there are development management issues fairly shortly after adoption. That doesn't mean that the plan-led process has failed, because the vast majority of the MPPF will have been carried through by your examination. There will be further substantial allocations of land. They will be in accordance with an overarching spatial distribution that has been said to be right. There will be up-to-date development management policies dealing with this highly constrained area, which is also important in terms of the plan-led process. So there will be a host of benefits attaching to a relatively early adoption of LPP2. And in terms of the availability of housing in the future, as has been said, that will be something that the local authority will need to keep under review, and it may choose to do it in various ways. The obvious way is by the necessary review of LPP1, but how the authority chooses to respond is to some extent a matter of the future. And of course, one of the things that will happen if this plan process moves forward relatively swiftly is that when the authority is charged with dealing with the review of LPP1, it will have the benefit of your report in deciding what its action should be in the relatively near future. So for all of those reasons, the situation has imperfections attached to it. That is undeniable, and I wouldn't seek to deny it. But in terms of whether or not there is substantial compliance with what the framework expects to happen when we're dealing with documents of this scope, the answer is undeniably yes. The position will be moved forward in a very large number of ways, which are important in terms of, amongst other things, the supply of housing.
Thank you. And Mr. Busey made the point, and he suggested the insertion of a policy relating to where neighbourhood plans might be underperforming. I wonder if you've had a chance to look at that in the statement, and whether I could have your reflections on it, please.
So I haven't considered the proposed wording of that policy in detail, and that's something we can certainly do if you think that would be helpful. But there is perhaps a more general objection.
Just in principle.
Yes. Yeah. So in terms of in principle, if that is to be done for one area, then as a matter of logic, you would apply it to each of the areas, and then doubtless there would be suggestions not necessarily based on the presence or absence of a neighbourhood plan, but based on what is perceived to be the presence or absence of sufficient levels of housing in a particular area in the other settlements, that something akin to that should therefore be incorporated in relation to those, by definition, some of them more sustainable locations for further development. So that's the issue in principle with that kind of redrafting. What that risks again doing is fairly serious violence, perhaps unintentionally, to the drafting and scope of LPP2.
Thank you, Mr. Beglan. Mr. Banner.
Thank you, sir. I want to come back on a couple of points that have been made. You asked the question, drawing from what I'd said earlier of Mr. Beglan, would the plan effect be out of date at adoption? Some of what he said in response didn't answer different points, but just on that specific point, first of all, he said, well, that the plan would still have a range of policies that would be up to date. No, because when there isn't a 5-year supply, paragraph 11D of the framework and the accompanying footnote deem all the most important policies to determine whatever the application is in question, deem them irrefutably to be out of date. One doesn't then sort of resurrect their up-to-dateness by reference to consistency with the framework. They are deemed irrefutably out of date. It's a 5-year supply. So Mr. Beglan's the only part of his answer that actually addressed your question is wrong. There were other points made that I would like to come back. He seemed to suggest that if you were to find, contrary to what the council's position is, that 5-year supply can be considered in the context of LPP2, and that applying the framework, the 5-year supply should be secured, that it would be open to you to effectively depart from the framework as a matter of public law, because you can say there's a policies there, but in exceptional circumstances you can depart from it. Well, a couple of points in that relation to that. Firstly, there's no exceptional circumstances put forward for a departure from policy. And ordinarily, there's a matter of public law, there need to be exceptional circumstances to depart from the legitimate expectation that public state of government policy generates. We want to be very slow indeed in the context of local plan examination to depart from national policy, particularly when the scope of the examination is soundness, as to which national policy provides the guidance. And secondly, it would follow, Mr. Beglan seems to say, oh, well, if you say you can sort of let it slide very easily in the event that they're wrong about whether 5-year supply is a relevant consideration. But it would follow, if 5-year supply is a relevant consideration in the way that's been advocated by myself and others this morning, that there are two fundamental failures with the council's approach to this plan. Firstly, it hasn't been positively prepared. It's not just a 5-year supply point in itself. It hasn't been, plainly hasn't been, if the council has been proceeding on the basis that it shouldn't and can't allocate more sites and or secure 5-year supply through this plan. And secondly, there would be a legal error which actually would give rise to a strong High Court challenge, because the council has ruled out, on the face of what you've been told, and it's all on YouTube, so the court will see a transcript, they won't be able to wriggle out of it later. The council's been very plainly told, so the EIP has been very plainly told that the reason the council has not assessed a higher allocation figure for the purpose of SEA is that the LPP2 cannot perform the picking up the slack remedial function, and it's no purpose of the LPP2 to demonstrate a 5-year supply. Now, those two propositions are wrong as a matter of law. It follows that the ruling out of a higher allocation figure as a reasonable alternative is not the exercise of a planning judgment. It is based upon a legal misdirection. And that means that the SA as currently stood is legally inadequate. So it's not as easy as Mr. Beglan suggests to let slide the lack of the 5-year supply. There's also a rather unattractive, it's almost explicit, but it's certainly implicit, blackmail to you. Because what the council is essentially saying is that if you were to find that more sites need to be allocated, we will take so long to do that, that there would be a delay which would be against the public interest. A very, very unattractive position for plan making authority to adopt in the context of a need to provide for identified needs for housing. To say, well, we're just going to drag our heels, and therefore you either take this inadequate version of the plan or we'll put the brakes on. Very, very unattractive indeed, sir.
Thank you, Mr. Bennett. Responses to that, Mr. Beglan, before we move on.
Well, so there is perhaps a comfort in being recorded on YouTube, and that's, as Mr. Banner says, that any court that wants to can look at precisely what the local planning authority's position was and can judge for itself. So whether my observations about delay and some of the practical ramifications of the suggestions around the room amount to blackmail, or whether I said anything remotely along the lines of we would deliberately put the brakes on. But there we are. Now, in relation to the points that have been made, perhaps it's not trite law, but I thought I was recording trite law to you when I read from paragraph 70 of the judgments earlier that there is the ability to depart from guidance should you feel it appropriate to do so. There doesn't have to be a test of exceptionality attached to that. And moreover, as the planning courts have repeatedly said, planning inspectors often find themselves in situations where pieces of guidance are pulling in slightly different directions. There may be tension between them that you need to resolve for yourself. The MPPF and its application to the scope of this plan as a whole, and you'll do so primarily by applying the test of soundness to it. Now, seen in that respect, if there is an obligation in relation to 5-year housing land supply that you decide, as I say, other things being equal, as a matter of policy, should be applied, there are a host of good reasons to move away from that position in this particular case, as I indicated, and the weight, that this is trite, but the weight to be given to those considerations is a matter for your judgment in applying the tests of soundness. And so the suggestion that should you apply the test of soundness in that way and reach your own judgments, that somehow the High Court would be rushing to strike down a process that is undertaken in that fashion, that may be premature to say.
Very judiciously put this up, so but I did very important that the arguments are properly characterised, because they haven't been. The point is that for the SA purposes, it's the council who has to make a planning judgment as to what are the reasonable alternatives. It can't outsource that planning judgment to you. So, well, we've not looked at high allocation figures, but that's okay because you can. You're examining their plan. Their plan hasn't been positively prepared by them, and their plan hasn't, in the SA context, they haven't, as is their task, not yours, they haven't tested the reasonable alternatives, namely higher allocation numbers, because they have proceeded on the basis that it's not open to them to explore that possibility.
So I don't want to elongate this or prolong it longer than is helpful, but it's important to recognise that there is a difference between whether or not we are obliged to take a course and the course that we choose to take. The course that we chose to take, involving our own planning judgments, is that set out, most importantly for the purposes of this, the first question of yours that we're dealing with, the judgments that we took about the proper scope of LPP2 that was submitted for your examination on that basis.
Thank you. So I want to move the discussion on now, and in terms of what's been a theme of a number of representations and hearing statements, and this is the potential undersupply against the plan requirement. And I wonder, to introduce this topic, if I could invite Mr. Neame in, please, just to give us an overview of your analysis, please.
Yes, thank you, sir. I will take the written statements and the detail as read, naturally, but just to take you through the headline position. So I think before we look at our position, it's probably worth just dwelling briefly on the trajectory for delivery that was set within the appendix to the Part 1 plan. So that's Appendix C, sir, which you should have. And yes, Appendix C to the Part 1 plan. And if you can perhaps just have that open, we'll come back to that as we progress. But that is the basis upon which the housing delivery strategy set out within the LPP1 was established, and the basis upon which your colleague found that plan to be sound, the expectation of delivery for certain components of the supply you can see set out, particularly in relation to strategic allocations and Dunsfold Aerodrome. I flagged those. I will come back to those, sir. We're now some 3.5 years down the road, and we have effectively the benefit of hindsight, which actually your colleague, Inspector Ball, foreshadowed in his comments in his report, that there are risks to the council supply, for example, variations to the start date and delivery of Dunsfold Aerodrome, and of course, unforeseen impediments to bringing other sites forward. we're now able to see, with the benefit of hindsight, what's happened, particularly to Dunsfold Aerodrome, what's happened in terms of impediments to supply from other sites. And that, of course, is material to what the local plan part 2 should be achieving, as we've set out, and I'll quantify that as we go through. So you don't actually have an update to that Appendix C in front of you from the council, or anything approximating that trajectory, save for the evidence that is attached to our statement and those of my colleagues around the table. For the obvious reason, I'll talk to the evidence that's in our statement, but you will, I'm sure, have read my colleagues, particularly Miss Ashton to my right, and you'll see that actually there's not a significant difference between us. So what I've sought to do to assist you, where the council has not, is to take the current position as the council has it in terms of stated completions, committed sites, and then the delivery that the council expects from allocations made through neighbourhood plans that have been made, the local plan part 1 strategic sites, and of course the allocations that the council is proposing through this part 2 plan. And those delivery expectations have then been updated to reflect what is the most recent data in terms of the council's acceptance that it doesn't have a 5-year housing land supply, and how that position has been established through, as you will see from the note from Mr. Banner, a plethora of Section 78 decisions, but critically 3 decisions which I've referred to in evidence, and I know that others have as well. So this isn't me projecting what the position would be. This is based on the factual position. And I think we just need to focus on 2 components of that supply for present purposes. You'll see from the detailed tables that I've included in our statement, we have looked at every single source of supply. But the 2 key components are primarily Dunsfold Aerodrome, sir. And I'll take you back to that Appendix C, where you will see that at the time of the plan adoption, the council expected houses to be on that site in the monitoring year 2019-20. 37 houses. And you'll see the trajectory runs through to a peak of 257 dwellings per annum to reach the requirement of 2,600 dwellings. If we then look at the position today, so the position today as the council has accepted, must have accepted in terms of the approach that it takes to development management decisions, which has been tested at length through various Section 78 decisions, is the peak delivery from that site is significantly lower, and completions from that site are unlikely to commence until 2026. Now, so that gives us a total for the remainder of the plan period of 790 dwellings. So just on that one site alone, sir, we've got a hole of 1,810 dwellings. That's a hole that's not being filled by the Part 2 plan, bearing in mind that the scope for the Part 2 plan, and I know that Mr. Beglin was at pains to take you to various paragraphs, but the Part 2 plan does make plain in the introductory section 1 that it is to be prepared in conformity with the Part 1 plan. And part of that fundamental conformity is to deliver the housing requirement, the minimum housing requirement. I'll just draw you to one other example, sir, because there is another participant around the table that I'm sure will want to speak to this in more detail than I will, and that's the position in relation to the Milford Golf Course site, sir. And that site clearly will not be delivering any housing, and I will let Mr. House speak to that in due course, because I'm sure he will want to. that again, sir, represents a reduction of another 160 dwellings. Now, I could go through the multitude of supply tables. I won't do that, sir, but I think the point being made here, I think is a clear one, and it's clearly conveyed in my trajectory 1 table, that when those factors are taken into account, and of course on the supply side, the council has had an increase in supply primarily from Section 78 appeals. But so when that increase in supply is taken into account, the net effect is a shortfall of 1,250 dwellings over the plan period against the minimum housing requirement. So that's 1,250 dwellings that need to be allocated to get to the minimum as defined by the local plan part 1, not to exceed it. And that takes account of all of the proposed allocations that the council has in place within the submission version of the LPP2. I think those are the main headlines I want to run through at the moment, sir, but I do want to pick up on a couple of points that were made on day 1, because you raised a very helpful question in terms of whether the requirements for the settlements in the LPP2 are based on relevant and up-to-date evidence. And you'll see that the council's answer to that is set out in paras 7.1 to 7.5 of its response to your initial questions. And then again, there's an update to that position in the Matter 6 statement. What I just want to draw to your attention, sir, is that across those 2 documents, the council has updated, amongst other things, its completion and windfall data. And it's updated it at 2 points to 2 base dates of the 1st of February 22 and the 1st of April 22. None of that data, sir, is before the examination, because the only data that the council has available publicly currently is to the base date of the 1st of April 21. And so that same point carries forward actually into Mr. Beglin's opening, paragraph 4, where he referred, you may recall, to the average completion figure of 640 dwellings per annum across the borough over the last 5 years. So the evidence for that figure is not before you. I can't calculate that figure. The average over the last 5 years from the publicly available data is 539 dwellings per annum. If the council is to rely on that, and therefore for you to have the accurate position, that data needs to be made available. Now, I assume, sir, because the council updates its position to a base date of the 1st of April every year, that actually what the council is relying on is the data that underpins what will become its next 5-year housing land supply position statement. Presumably, if the council has the windfall and the completion data, and given that we are within that monitoring year, it would be extremely helpful to you within this discussion if the council is to make that data available, because it may, to the council's benefit, assist with the position in terms of that shortfall that I've referred you to. It's certainly not going to close that gap of minus 1,250 dwellings, but you do need to have sight of that data. So hopefully that's been helpful. If there's any particular points that you wanted me to cover that I haven't covered, I can do that now, or I can come back on, as I'm sure there'll be various points in discussion.
That's fine. Thank you, Mr. Neame. I'd like to bring Mr. House in on the points on the Milford Golf Course, please.
Thanks so very much. I think I can be brief on this. I mean, my wife and I have set out in the hearing statement the current position relating to the non-delivery of one of the LPP strategic sites, namely Milford Golf Course. For the reasons also given in section 4 of our hearing statement, we do share the view that's been expressed and put much better by Mr. Banner and Mr. Mouls than I could do, that it is appropriate for the LPP2 examination to consider the non-deliverability of the strategic sites. I didn't participate in that part of the discussion, but I just wanted to make it clear that that is our position. It does seem to us to be a very distinct issue from seeking to revisit or review the objectively assessed need or the housing requirement. And I want to make it very plain that we're not suggesting any such review. No doubt that can be done in the next 5 months before the LPP1 revision. The Milford Golf Course site, as Mr. Neame says, does account for 160 dwellings in the 5-year housing land supply statement for Whitley and Milford. And as neighbouring owners, we have a restrictive covenant that prevents that development unless the covenant is modified or discharged by the Lands Tribunal. Now, that much is acknowledged in Appendix 4 of the 5-year housing land supply at paragraph 1.28. And so that raises the question in my submission for this examination of LPP2 about what evidence there actually is before it, which can give any confidence that the covenant will be modified or discharged to permit the proposed development. And as others have said, that is an issue that has cropped up on a number of Section 78 planning appeals in the last 2 years. But if you look, and we could go to it, but if you look at paragraph 1.28 of Appendix 4, what that says is that Carla Homes, now Carla Homes is the developer, it's not the owner, but it's the developer, have confirmed that they are aware of the covenant and that they plan to address it before the development commences on site. It goes on to say that correspondence with Carla Homes confirms that they have set aside 18 months in their build program to address the covenant. Now, we've asked WBC and we've asked the developer Carla what correspondence there has been that has satisfied WBC that the covenant will be, in their words, addressed. And neither WBC nor Carla have engaged with us on that. But we did put in a Freedom of Information request to the council, which revealed that all there is by way of correspondence is a single email from Ian Humble of Carla to Zach Elwood of WBC, and it's dated the 21st of July, 2021. And what it says is that in terms of the queries, we would anticipate a 15-month period to get through the land tribunal process on receipt of reserved matters consent. As soon as the covenant is resolved, we would intend to start on the site. Now, sir, I think the language used both by WBC in its 5-year housing land supply statement and in its request to Carla for evidence to support its 5-year housing land supply statement and Carla's reply to Mr. Elwood is actually very revealing. The relevant question to Carla should have been, why are you confident that the covenant will be discharged or modified to allow this development to proceed? But strikingly, that's neither the question that seems to have been asked, nor is it the question that was answered. The developer's answer is, in effect, just my estimate is the process is going to take about 15 months. Now, in my submission, that's really the equivalent to a gambler asking what are the chances of winning the Grand National and being told what time the race is expected to finish. It doesn't tell you anything about the results. And I think that's probably why successive Section 78 inspectors have concluded that there's no evidence sufficient to justify the MGC site being included in the 5-year housing land supply statement. And details of those inspectors' findings and extracts of their decisions we've annexed to our statement, but others have referred to them as well. And now, if there's a sort of slight sense of frustration coming through my voice, it's possibly because throughout this entire process of the evolution of LPP2, from June 29 onwards, we have taken the time to write to the planning officers at WBC to explain exactly where things lie with the covenant, including explaining in detail in our view, the case law developments in that time, which are, and our counsel believe, continue to strengthen the case for upholding the covenant. And we've explained the reasons for our confidence in our legal position. We've explained the expert advice that we've got to support the council's advice. And at no stage since then has there been any engagement at all on the issue. And it's not in the bundle, and there's sort of no reason why it should be, but I can provide that evidence and that correspondence if it's useful. So just to be clear, it remains the case today that no application has been made by the owner of MGC site to discharge or to modify the covenant. And that is the position despite the fact that they obtained full planning permission on the reserve matters over 8 months ago. So there's no application extant. It also remains the case, because I've heard it suggested actually on behalf of the council at some of the Section 78 appeals, and I've heard it referred to elsewhere. We are not involved in any discussions to be bought out from the covenant, and we have no intention of resolving this issue in that manner. We do intend to enforce the covenant. And so in our submission, taking it right back to the start, really, if LPP2 does not cater for the contingency, and in my view, I would say the high probability that this LPP1 strategic site will never deliver the proposed housing that WBC has allocated to it, then LPP1 will be unsound because it will have failed to meet the criteria of being positively prepared and justified. So that was all I was proposing to say.
So in terms of that lands tribunal process of discharging or modifying the covenant, I mean, I take into account what inspectors have said at appeals on this, but so they've discounted it from the 5-year supply. But is there a possibility that in the longer plan period, if that process was gone through, that then, you know, some development could occur on the site?
There's been some confusion over this as well. I mean, if an application was started tomorrow before the Lands Tribunal to modify or discharge the covenant in order to permit the development on the scale that's being proposed, and we resist that, which we will resist it, then the guidance given, the current guidance given by the Lands Tribunal is that they attempt to get all of their matters resolved within 70 weeks, and they are successful in 70% of their cases. So 70% of their cases, I think by implication, the less complex and less controversial ones, they aim to conclude within 70 weeks. So I think that you know, that is the guidance, and that's the duration of it.
Thank you. Mr. Banner.
Thank you, sir. Mr. Neame left me to introduce that table that I referred to a couple of days ago. Could I ask you to take it out? It's on the website under action points. Submitted by Henry Adams. It's what I'll do is I'll just explain what it's intended to show, and then in the context of the examination, explain what I'm asking you to take from it. So this is a succession of 16 appeal decisions where 5-year supply has been tested since LPP1 was on the cusp of adoption. It was adopted in March 2018, so the first 4 are where the LPP1 was coate but not yet quite adopted. And the as you can see, there's listed the dates, inspectors, then it's what the inspectors found in relation to 5-year supply and what they were told by Waverley, by contrast. The bold text is those cases where Waverley were contending a 5-year supply above 5 years and the inspectors found less, and you'll see immediately that's all but 2. And of the remaining 2, the most recent one, they still were found to have overstated the 5-year supply by 0.7 of a year. what do we ask you to take from this? I think 3 main points in the context examination. Firstly, this shows, alongside Mr. Neam's analysis, it shows that delivery is not as, delivery of the LPP1 minimum requirement, that is not progressing at the speed that was envisaged at the time of LPP1. I emphasize minimum requirement because, of course, the at least words indicate that there is scope for an uplift within the parameters set by LPP1. And it's a little bit more than simply delivery not being as envisaged, because there's no indication of any uptick. If one looks at the third column, 5-year supplies found by the inspectors, at best being perhaps slightly charitable to Waverley, it's flatlined. If one was being a little bit less charitable, one might look at the last 5 decisions and note that if anything, it's gone down a bit since 2020. But I'm prepared to proceed on the basis of flatlining. So there's no suggestion that the position is being recovered, and it's a sustained position over what is now 5.5 years, I think. So that's the first point, which reinforces the case for picking up the slack if you were to find that that is within the parameters of LPP2 as we've advocated. The second point is the consistent failure over pretty much all of that 5-year period by the council to recognise, until the last decision, the existence of the problem, and even now the scale of the problem. I mean, I think the boy who cried wolf twice, but Waverley Borough Council have well surpassed that boy. And that means a number of things. Firstly, it reinforces our concern that the plan hasn't been positively prepared. This is not, frankly, a local authority that has acted positively in relation to housing, because it's proceeding on the basis that there hasn't been a problem in relation to 5-year supply, and persistently found by inspectors to be wrong. And rather than respond and react to those inspector decisions, they've dug in and effectively denied the repeated finding of the inspectors. So it reinforces that the plan hasn't been positively prepared. And also, if you are provided with the latest 5-year supply material, suggests you might want to apply a very high degree of caution as to what the council claim its 2022 base date supply is. And thirdly, as Mr. Neame says in his written representations, the repeated findings of this succession of different inspectors as to 5-year supply undermine the reliability of the LAA as evidence supporting deliverability. And of course, they'd rely upon that in the context of the present LPP2 as well as in the context of LPP1. So that's what we asked you to take from the table. I think you've got most of the decisions in various people's representations. You've got some of them about 5 times. But if there's, I don't think anything turns on the ones that you don't have, but obviously if it does, we can provide them to you. Thank you.
Thank you, Ms. Ashton.
Thank you, sir. I'm not going to reiterate what Mr. Neame's already said about the situation at Dunsfold, and likewise the position as it stands at Milford Golf Course as set out by Mr. House. I think it's quite clear from the number of representations you've got before you that there are a number of us that believe there to be significant issues with the housing land supply situation as it currently stands. Likewise, there are a number of us that have provided tables, graphs, etc., that set out the situation with the consistent under-delivery over the course of the plan period. The situation for you, as you put it at the beginning of this inquiry, is how do we actually find a solution-orientated approach to dealing with this? And I, for my point, just want to address the situation at Milford, if I may. The current situation as it stands in table 1 of the council's matter 6 statement suggests completions of 100 units in Whitley and outstanding consents for 188. That's on page 3 of their matter 6 statement. Clearly 160 units of that 188 aren't going to be delivered, there's no indication that the covenant at Milford Golf Course will be resolved, and therefore I think you can't take it as read that there are 188 outstanding planning permissions that are deliverable within Whitley. You therefore end up with a situation where you have 129 either completions or outstanding planning permissions within Whitley, and therefore a shortfall of, can I have this nearer to me? A shortfall of 299 against the 480 that was actually identified within the Local Plan Part 1 Policy ALH1. If you take all of the Regulation 18 sites that were identified as potentially deliverable at Reg 18 stage and subject to SA, they cumulatively amount to 220 units. They, together with the 129 completions or outstanding commitments, would give you a total of 349 units, i.e. still a shortfall against policy ALH1. That shortfall would be in the region of 131 units. You then have the situation with secrets that's been identified through the submission plan for 177 units, and you have others promoting sites that were asterisks but not actually identified within the Reg 18 plan for 70 to 120 units. You have a situation within Milford where you can address the situation. I appreciate it's not for you, sir, to suggest where that situation should be addressed and how, but I think it's common between a number of us around this table that within Milford it could be addressed, and it could be addressed by accommodating what has been identified as deliverable, and provide you with a situation where, yes, you actually might have something that is slightly above the 480 that was suggested or identified within policy ALH1, but nonetheless would provide you with a sensible buffer within an area that's identified for delivering moderate growth within policy SP2 of the Local Plan Part 1. So again, you're totally in compliance with the policy approach in Local Plan Part 1. You would also have a situation whereby you're addressing what in effect was suggested within the Mid-Sussex Local Planning Inspector's report of providing yourself with a buffer, but a buffer that actually addresses the spatial strategy within the LPP Part 1. And in addition to that, I know some people will turn around and say, well, some of these sites were identified for within the AONB. Yes, they might do. But when they were identified as asterisk sites, that was well known to the inspector at the Local Plan Part 1. He still accepted that approach, and therefore the alleged harm to the AONB, as suggested by some, I don't think does exist. They have all been, as I say, suitably assessed through the SA process, found to be totally appropriate for promotion through the Reg 18 plan in many instances. So therefore, there is a very quick and easy way for the local authority to address this situation in Milford. I can't comment for anywhere else. Others promoting sites in Hazelmere will no doubt come up with similar strategies.
Thank you, Mr. Berendt.
Thank you, sir. I really would agree with the points that have just been made by Ms. Ashton and Mr. Neame in terms of delivery. But I think it's coming back to a broader point I'd like to really make in terms of the lack of evidence in terms of overall supply within the plan. I think as we've all had to search around for what that delivery and expectations are over the course of the plan from various sources of data. I think what is alarming is that the council haven't undertaken that work to understand what that supply is going to be like over the course of their plan period towards the end, to ensure that when this plan is prepared, and actually in terms of determining what the scope of this plan should be, that it meets need, which does link back to the LPP1 in terms of what its intention was. If you're setting a scope for a plan that, and you don't have the evidence in terms of what that is going to be delivered, then that scope is essentially flawed in terms of what it's seeking to deliver. And I think that's the problem I have with this plan and with the evidence base that's supporting, is that it hasn't fully examined or considered what delivery would be. We have had to go away and actually try to identify and seek what that is. And I think that really needs to be clarified. And I think it does point to a problem with the council in terms of that did it know that it wasn't going to meet need in full? Did it know that there wasn't going to be that 5-year land supply? And actually, that should have been one of the critical elements in terms of the preparation of the plan, including what the scope of the plan should be, sir.
Thank you, Mr. Wood.
Yeah, thank you, sir. Just a couple of points. The first one is a clarification. In Ms Ashton's hearing statement on this matter, at paragraph 6.23, there's reference to a covenant on the secrets land. Just to clarify that there is no restricted covenant preventing the delivery of housing on that land. The reference to the restriction in that covenant is actually a historic one from the 1920s that links to the land opposite the golf course site, and we can provide that to you if it is helpful. And then the second point, just building on the point we heard earlier as well, is that if additional housing is required in Milford, the secret site has capacity to provide more than 177 allocated within the plan at the moment. We've been in discussions with council planning officers through pre-application, engaging with the local community, and have actually submitted a planning application that can deliver all of the allocation requirements and 216 homes. And within that includes over 6 hectares of open space, so well within the density of the surrounding area. Thank you.
Mr. Hon.
So thank you very much. Just 2 short points from me. First, we agree with Miss Ashton that a solution is needed for Whitley and Milford for the reasons given because of the lack of deliverability of the golf course. And second, we agree that a solution can be found through the sites that were initially identified. And just to reiterate that the Petworth Road site is not in the AOMB and gives you, sir, a significant degree of flexibility, because on the one hand, it could come forward for 120 dwellings, or it could come forward for 70 dwellings plus a SANG, which unlocks, i.e. provides a SANG for other sites in the vicinity. So in terms of what I might term the Whitley and Milford solution, we think A, that's a good one, and B, it's certainly workable. Thank you, sir.
Thank you. And Mr. Munton.
Thank you. Firstly, just to endorse Mr. Neame and others, this plan has to pick up the slack that we've discussed this morning. I think otherwise it is unsound. I think it's a shame the scope hasn't picked that up. It could have done and should have done. Just in terms of Milford itself, again, fully support and endorse Miss Ashton. The easy, quick solution, if we're worried about time, and we should be, is that you have the asterisk sites. The Reg 18 found those sound, and if further is needed, which it seems to be, you can add in secrets or other sites. I think the solutions are quick and easy to deal with. Thank you.
Thank you. So in terms of reflections on those points, so no doubt you'll have seen Mr. Neame's analysis. And I wonder if you're able to give us a response to that orally now, or whether and we'll see how far we get with that. And in terms of whether there's any written submissions need to be made that we could come back to perhaps later next week.
So yes, thank you. I think to answer those questions, I am going to pass further down the table.
Yeah, thank you, sir. In terms of the information on housing delivery, we've taken our cue from MPPF paragraph 74, which requires that strategic policies should include a trajectory, and that's what LPP1 does. And we've been referred to Appendix C this morning. that paragraph of the MPPF also states that all plans should consider whether it's appropriate to set out anticipated rates of development for specific sites. And notwithstanding our views around whether this plan needs to explicitly address that, we can provide anticipated rates of development on the allocated sites for you. And I believe we could do that today in all likelihood, because that work is ready. And furthermore, if in the light of the discussion this morning, the inspector would find it helpful for us to provide an update on Appendix C of LPP1, we can undertake that work. And I'm confident that we can turn that round relatively quickly, but probably not today. It will be a few days. So early next week would suit us, if that's acceptable.
Thanks. Yeah, I think that would be useful. It's just a question. We've got the contingency session. Charlotte, could you remind me when that? It's a Thursday afternoon, isn't it, next week?
Yes, Thursday afternoon. Friday.
Yeah, so it's next Thursday afternoon session starting at 2. We've got a contingency session. Just a question of whether I'd like that written material. It's a question of whether people will be in a position to come to the contingency session and discuss that. Just looking around the table. Mr. Good.
Unfortunately, I won't, sir, as I'm elsewhere with one of your other colleagues at a different local plan examination on that day, which we've already committed to. I therefore wonder whether there is another method in terms of written reps for some of those on a fairly short timescale, if required. I have to stress they may not be required, but it's a potential process. Obviously, you could pursue, sir.
Thanks, Mr. Good. I'll consider that. Is there anyone else struggling? Mr. Banner.
I'm in the High Court in the morning. Would you be happy for me to access it remotely from chambers? So I can do that then, I'll.
Okay, thank you. So if we can proceed on that basis. On the point of the requirements material, so there's a main modification being proposed in terms of the requirements for the settlements that are covered by the LPP2. And that seeks to move the base date to 1st of April this year. So I think we've heard from Mr. Neame in terms of the evidential underpinning of that. So if that could be supplied as well, please.
Yeah, certainly, sir. And in addition, we can provide the latest information from the promoters of Dunsfold Park, because clearly that's a big issue for this examination.
Do you have any specific reactions at this stage on what we've heard on Milford Golf Course?
Again, I might look down the table after making some initial observations, but of course, Milford Golf Course, one of the strategic allocations, as you are aware, and the position that has been articulated very clearly by Mr. House today was a position that was taken before Inspector Ball. So these issues were ventilated at the stage of the examination of LPP1, and he received further submissions from all the interested parties. And it was on the basis of all of that evidence being available to him that he decided, as a matter of one of the strategic allocations, that it remained appropriate for Milford Golf Course to go into local plan part 1. Now, in terms of the nature of the arguments that are being advanced, they are now as they were then. And I think Ms. Dove will tell me, but we've made provision, as it were, for that within the trajectory when we think that the golf course is likely to make a significant contribution. And so your question was, what can it happen later in the plan process? And our view is that it remains a strategic allocation, and yes, it can. I'll just see if any of my colleagues want to add on that point.
So is that based on more up-to-date engagement with the developer of that site?
I believe it is, sir, but I think when you'll see the trajectory information that we're able to provide, it's a case of pushing it to the back of the plan period rather than an early start date.
Okay, so we'll discuss that in more detail in the round next week. But Mr. House, if you've got anything specifically on that.
Can I just respond to Mr. Bigland's point in relation to the situation effectively being dealt with and or equivalent to where it was in February 2018? I think there are about 10 points of distinction in relation to that. The first I make is that the legal advice that the council had got, which was before the inspection in 2018, attempted to cast quite considerable doubt on just on the legal enforceability of the covenant. That point, as the council knows, has subsequently been conceded by the lawyers for the owners of the site. The second point is that the legal advice that was given to the council at that stage was on the basis of a first instance decision in relation to the Alexander Devine, which is the principal case on public interest, which was one of the grounds on which they thought there might be some mileage, and that's been overturned in the Court of Appeal and upheld in the Supreme Court since then. The third point, which I think is a point of some relevance that others are making more generally, is that nearly 4.5 years have passed since Inspector Ball's report, and still no application has been made under Section 84. Point I made previously, but it's also true now. My fourth point of development is that 8 months have passed since detailed planning permission was given, and still no application has been forthcoming. And there are some other points of distinction that follow on, all of which the council are well aware of, because we've kept them up to date more or less minute by minute in relation to what's not happening in terms of a Section 84 challenge. But I think those are the principal points. Of course, I mean, the other point of distinction, which Mr. Beglan doesn't seem to address, is that whereas in February 2018, Inspector Ball came to one view on a balance of probabilities, umpteen Section 78 inspectors subsequently, with more up-to-date information and with the point fully argued in front of them, or partially argued in front of them, have come to the opposite conclusion. And so it seems to me to wind the clock back to 2018 and say done and dusted is further failure to address the real substance of the issue.
Thank you. Mr. Neame.
So thank you. It's just a question, actually, if I may, through you. So the council have undertaken to provide various documents and updates. Can I ask when that material will be provided, bearing in mind the contingency session is a week today, just in terms of giving parties around the table an opportunity to consider it and therefore make best use of the examination time when we reconvene?
Yes, so I think I indicated that we, in all likelihood, we can provide the trajectory, site-specific trajectory information today or tomorrow, but the overall updates on Appendix C of the LPP1, we'll endeavour to do that for Monday, if that's acceptable.
Yeah. Okay, yeah, so that would be useful if we can get that. So given where we are, and we're going to come back to discuss that next week, Mr. Munton.
Sorry, I felt as though you were going to draw close to this, which is probably right. But there was one point I forgot to pick up a bit earlier when I spoke, and it's our reps to this matter and table 2.1. Very quick point, just to point out to you that there was a double counting in our table 2.1, where we've included DS12, DS13 twice, so it's included in A and B. So it's a double counting of 27. I just wanted to pick that up before I forgot again. Thank you.
Ms. Ashton.
Sorry, fighting with my laptop. Just a couple of things, if I may. First of all, if I can take you to paragraph 6.2.2 of my matter 6 statement, where I've set out the inconsistency between the expected delivery timetables set out in the LAR and the council's response to your preliminary matters. In that section 9 of Waverley Borough Council's LLP 201 suggests that Land Secrets isn't expected to deliver until the latter part of the plan period, whilst the LAR addendum suggests it's going to be delivering in years 1 to 5. Now, clearly, the expectations in terms of delivery and when delivery will take place has implications as to the scale of development that can be delivered from that site during the plan period. Whilst I note what those promoting secrets say about the potential for it to deliver more within the plan period, clearly it is only one site and it has a lot to do before it can start delivering. They themselves accept that there are buildings that need to be redeveloped, there are things that need to be moved, there are various different things that need to be addressed on that site. My suggestion to you that could be put to the council is that there are alternatives available through the development of a number of smaller sites that would significantly help address the 5-year housing land supply shortfall. In addition to that, I have to say, find it slightly ironic that secrets on the one hand say they have a defensible greenbelt boundary and on the other say that they can actually deliver a hell of a lot more than is being promoted within this local plan. But I'll leave that to them to justify.
Mr. Chapman.
Thank you, sir. I wasn't going to bring it up at this stage. I thought it'd be more apt to do that later on today. But as my colleagues around the table are making reference to this to site specifics, both the sites that that we're looking to promote in Milford, whilst being smaller sites, they are available more or less immediately. So yeah, could come forward at any time. Thank you.
Mr. Wood, I thought you might want to come back in.
Yeah, just a quick response to that. We actually communicated with the council earlier this week about anticipated housing trajectory on secrets. With a good win, we envisage that we can be on site by 2024 and be fully completed by 2028. So delivering, within the short term. And then in terms of numbers, you'll see the master plan appended to our hearing statements. We are delivering those 216 homes I mentioned within the site boundary and providing, retaining the existing buffer that exists on the site to the northeast, and then providing a reinforced buffer to the northwest. Thank you.
Okay, thank you. So I suggest we adjourn this session now and reconvene next Thursday at 2 to discuss the material that's going to be supplied and also the remaining questions I have on this topic. So thank you all for your contributions this morning. The hearing session is now adjourned. Thank you.
Thank you, sir.